Hey,
Yes,
please, Lordship. Lordship, I filed a writ petition on 30 July, Lordship. Made a mention on Friday, Lordship, to be filed here, Lordship, with a prayer to list it on tomorrow's court list, Lordship.
what is the matter about?
Demolition of an unauthorized compound, Lordship.
It has been demolished. You have an interim order.
It can be listed, Lordship, for motion, Lordship.
Yeah, I've given you the permission earlier.
Okay, but it is not listed, Lordship.
We list it tomorrow. Let's take it, check it out with the registry. It may be listed in the supplement.
It's not.
It may be listed tomorrow in the supplementary list. Tell the registry. No, I don't give twice the same thing. If I have given that permission, there is a number out there, they will obviously the registry will list it. May come up in the supplementary list. The list for tomorrow's supplementary is it out? Then find it out. Then tomorrow, if it is not listed, I'll take it up. Yes, what do you have to argue?
8th of general process.
तो ऑर्डर क्यों है जी? Anybody refer to this Himanshu Roy? No, no. Why is this municipal amendment? क्यों है जी? Municipal Yes, tell me.
Yes, Your Honor. As per section 8 of General Clauses Act,
General project conduct.
section 8.
Yes, what is it?
So it says, if a provision is brought from an act, and later on that act has been repealed or amended, that effect does not come to the borrowed act. This is the principle, my lord.
This act, any so and so made. So this is something to do with provision by which legislation by incorporation.
Yes,
But can you say that executive instruction is a legislation by incorporation?
Milord, in the section itself, Milord, the word instrument is there, Milord. Instrument,
Where
in subsection 1.
where this act or any central act or regulation made after the commencement of the act repeals, renects with or without any the former enactment, then references made in any other enactment or any instrument to the provisions so repealed shall, unless a different year, be construed as reference to the provision enacted.
Yes. So, applicable.
Yes. Paragraph?
Milord, paragraph 11.
As part of provision.
Last paragraph, my lord. The expression is also used to signify a deed inter partes or charter or record or other writing of formal nature. But in the context of the General Clauses Act, it has to be understood as including reference to a formal legal writing, like an order made under a statute or subordinate legislation or any document of a formal character made under constitutional or statutory authority. Now, Milord, the analogy of the case is similar, Milord, in this case. We have no doubt in our mind that the expression instrument in section 8 was meant to include reference to the order.
No, we have no doubt that in our mind that the expression instrument in section 8 was meant to include reference to an order made by the president in exercise of his constitutional powers. Now, here, we may also go into the concept of any notification. Let us not go to the power or extent of the powers of the president. Even a notification issued would have the same effect. But it has to be done in exercise of the powers under 166. Now, is the notification, is that the by which it was incorporated that they will deal with that? Is a notification to that extent?
They have filed an affidavit. That they have indirectly said that they have delegated the power.
No. Delegation, some officer saying yes or no, this and that would not.
Government has filed the affidavit.
No,
Government
whether
has
it is, it can be brought within the ambit of a notification.
Yes, Milord, in this
Now
judgment
constitution is-
itself- in the judgment itself delegated. The judgment itself, the word delegation is referred here. And
Delegated to whom?
delegated to the commissioner or the heads of the offices.
No. The power has to be there. You see, a delegation, just for example, for the president, it is being delegated to the secretary. If it is for the governor, it is given to the commissioner and secretary of the department. It has to be by way of a notification. Finally, come to 166(2). Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in the rules to be made by the governor, and the validity of an order or year which is so authenticated shall not be called in question on the ground that it was an order, not an order or instrument made or executed by the governor. So under such circumstances, this notification by which there was an incorporation has to be a notification in the name of the governor. If it is to be construed as some instrument,
It has said.
no, just for example, tomorrow the commissioner or any official comes up and does anything, would it be construed to be binding on the government?
If government ratifies that itself.
No. If the
By-
government does not ratify
because
also,
that affidavit may be looked into. That affidavit may be.
let us see that order by which it has been done,
Yes.
by which it has been done.
At page 17 of my review application,
Your review application is number
page 17, number we wrote
28.
28,
28?
28.
No. 128. This is a circular.
They have termed as it is
So this circular cannot hold the file.
office memorandum.
So what? A circular is binding. A circular may be binding on the officials, not on any other thing. That is the law.
Of lordship, if their affidavit, they have ratified this one. That affidavit filed by them regarding this OM. That is clear, my lord. The commissioner was empowered to do so.
By whom? Who empowered the commissioner to do so?
It was not exactly.
No, it has to be given.
But
A commissioner, just for example, a commissioner of taxes. What is the power of the commissioner of taxes? Let us see that this is done under 99 VAT Act condition. VAT Act. 99 Assam General Sales Tax Act was holding the field. What is the power of the commissioner? Let us see. Can he be delegated to make laws as regards promotion? He cannot.
so the commissioner was given the power.
They don't have the rules.
Commissioner of taxes.
They don't have any
They
rules.
don't have any.
So under such circumstances, let us see who has given the power. Where is the power? Commissioner comes up and he does everything out there. That doesn't make him a area. Has to realize that this type of area. For carrying out the purpose of this act, the state government may by notification appoint a person to be the commissioner of taxes together with such other person to assist him as it thinks fit and may specify the area or areas over which they shall exercise jurisdiction. This is the power.
Yes, that is the power, but.
Then
how-
person appointed area shall exercise such powers as may be conferred and perform such duties as may be required or under this act. Where is the power being given for coming up with these type of circulars? Yes, Mr. B. Gogoi. Where is the power being given to come up with these circulars? Or he makes it on his own? The power has to spring from Article 166.
Yeah. In fact, Lordship will see whether the circular again, page 17 of the review application for a moment. Why it was issued?
No, whatever may be. But does he have the power?
Why not?
The question is whether a person has the power to issue. A commissioner is appointed in terms of section 3
Right.
of the, at that point of time, this is 99. It will the Assam General Sales Tax Act 1993 holds the field. So his only power is to carry out For the state government may by notification appoint a person to be the commissioner of taxes together with such other persons to assist him as he thinks fit and may specify the area or areas over which they shall exercise jurisdiction. Exercise jurisdiction for the purpose of collection of tax, for the purpose of doing whatever may be. But for the purpose of appointment of a year, the power has to spring from 166. Where is that power? This type of circulars cannot be instruments.
So in fact, my lord, only thing it has been laid down. My lord, Lordship will see for a moment page 17, that's why I'm saying, my lord.
Yes.
It says, my lord, representation for promotion to the post of LD assistant cum typist are often received from grade 4 employees of different offices under this commissionerate. It is clarified for the benefit of all head of offices under this commissionerate that they themselves have to dispose of such representations. And the Commissioner of Taxes cannot pass an order in respect of such claims for promotion in their offices. The head of offices will have to follow the following procedure in the matter of promotion of grade 4 to the post of LDA cum typist. As there is no service rules for the establishment of the subordinate offices under this commissionerate, Assam Ministerial District Establishment Service Rules 967 is generally followed by the subordinate officers for guidelines whenever necessary. So, my lord, this is the clarification he has given that there is a general rule. In the absence of this rule, you will have to follow that. And don't hand over the representations to the commissionerate for take a decision regarding promotion. You are the authority who can do the needful. That has been clarified.
This cannot be said to be an instrument or by which, by
Exactly,
legislative, by
Lordship. That's what I want
incorporation.
to point out. It is
It will have a serious consequences.
Then we look at how this district establishment rule will be applicable in my case. If there is nothing, then how did district establishment rule will be applicable to our establishment? Because district establishment is completely different from tax department.
So you mean to say your appointment was illegal? No,
I am saying-
illegal.
I am saying that.
How did you
this
get
is
your
the
appointment at all?
authorized
No,
instrument.
Mr. Sahu, how did you get at all your appointment? An appointment being made without any rules, without any executive instruction, without any adherence to anything, amounts to an appointment being made illegal. So we quash your appointment at all. In review, I exercise the jurisdiction, go to the division bench.
This or that way, or any way, the district establishment rule was not borrowed from any source. That is not in the record, but anyway that was borrowed, Milord. Then why this principle given under section 8 of the general clauses will not?
No, it won't. If they borrowed this only for the purpose as a only for the purpose of this looking into this what you call as a generally followed in that manner, it is being only taken as an example that the okay you normally in all ministerial stuff this is being done in this manner. So kindly look into this and follow this.
That is one. That is.
But whether that direction could have been passed at all, and on the basis of which can it be said to be an instrument to bring within the ambit of section 8? An instrument has to come from a source of power. Where is the power?
That is my question, Milord. If they say that district establishment is applicable, where is that power? That is the same question, Milord.
Huh?
So district establishment rule says that to be promoted, I have to be graduate. Now, where is the power that they are saying that I have to be graduate by applying the district establishment rule, Milord? Where is that power?
No. The question is not that. The question is you belong to the ministerial staff.
Yes.
As you belong to the ministerial staff at that present position, the ministerial rules categorically say that you need to be a graduate.
Yes.
So this court thought it fit that as all other persons are given in a similar manner, why not that principle be also applied to you.
Yes.
Matter instinct.
It is without principle of legislation by incorporation and
Where is
legislation
the
by,
position of legislation by incorporation?
because that is the principle of
Where is the
interpretation of law.
principle? No, Mr. For becoming of legislation by, I would have understood. If it is an executive instruction issued by the commissioner and secretary to the government officer.
Just, that rule says, that section says two rules. One rules with the amendment that doesn't affect, and another says the rule affect the borrowed act. Will you kindly come to page, paragraph 16, paragraph 16. Paragraph 16.
Yes.
On a consideration of these authorities, therefore, it seems that the following proposition emerges. Where a subsequent act incorporates provisions of the previous act, then the borrowed provisions become an integral and independent part of the subsequent act and are totally unaffected by any repeal or amendment in the previous act. This principle, however, will not apply in the following cases: where subsequent acts or previous act are supplemental to each other, where the two acts are in perimeteria, where the amendment in the previous act, if not imported into subsequent act, would render the subsequent
Mr.
act
Sahu,
without.
I know what is legislation by incorporation.
Yes,
Principle is very clear.
yes.
But you have to therefore satisfy me that this circular amounts to an instrument or a legislation. That is what I am asking you. There's no quarrel with that proposition. The proposition, the best example, these are not there. The best example is this. In the case of Bangalore Development Authority, the judgment. What has happened? That act specifically refers to the Land Acquisition Act of 1894. Now, what was a question came as to whether you could still bring in the 2013 Act of Right to Fair Compensation on the basis that once you have applied, the provision categorically says that the provisions of the Land Acquisition Act shall apply. Land Acquisition Act 1894 was repealed, and by the right to fair compensation. The question was as to whether you can still, now should you go for the right to fair compensation or the repeal that? The Supreme Court said no, in view of the fact that this act, which is a subsequent act, have already taken into account that unless there is an amendment to this act, the act of the Bangalore Development Authority Act, making it that it is under the right to fair compensation, the provisions by which it is to be taken into account has to be under the Land Acquisition Act. Similar thing, let us go to the principle of this thing, the 1964 Act of Assam Acquisition and Requisition. If you see, what is the manner in which a reference is to be made? For making a reference under Section 12, you bring it, you have to do in terms of the Land Acquisition Act. Now, because of that act, you do not need it to be done in terms with Section 64 or 65 as per that of the 2013. What you need is to do in terms with 12 and 18 of the Land Acquisition Act. Because there is no amendment to the 64. But by virtue of Section 106, the provisions of this Land Acquisition Act as regards the compensation has to be done as per the right to fair compensation. That is another aspect of the matter. Irrespective of, because that by which it categorically says that except which are there in the fourth schedule, all other acts will come in. So therefore, now this is the principle. There's no quarrel with that principle. But first you have to satisfy me that this document is a legislation by instrument, incorporation, or at best an instrument. For being an instrument, it has to flow from the powers under Article 166. 166(2) gives a power by which can be delegated to a particular thing. And once it is being delegated, that person can do it. Now, where is that? To bring Section 8.
Yes, I do not have, but how they can follow that?
Mr.
That-
Gugoi, the
that's
best part is this. The best option is this. We have already set aside.
Fine.
Whatever may be, on whatever ground we have set aside. That he is not entitled. I'm not saying that he can be entitled. You can very well go for a fresh selection
Yes, if there is a vacancy now.
by incorporating the new laws. Patents. Problem solved?
They will do whatever,
No,
because we don't.
patents.
date
You
of
just come
selection-
up with one letter that we are going to follow this. Matter ends. What do you need to?
date of-
Because I set aside his. For whatever reasons, I've set aside that he's entitled to, as per them, not entitled to this. Because he doesn't require, neither he is going to get it, neither he is going to. This is a review being filed. However, you are still open. If there is no specifically incorporating this, you open it now.
Yes, of course, there I can. One more thing I'd like to point out. In fact,
And nowadays, Rangia's judgment is no longer there. The vacancy arises,
Yes, yes.
the law will apply. Now, in view of the new law, this is the new law which will come in. No problem with that. Problem solved with Mr. Sahu.
And one more thing, regarding the ROP, I've checked the ROP. Same pay scale has been given, which has been given to the junior assistant who are under this particular Act of 1967. They're getting the same pay scale, same grade pay, meaning thereby that they're in the equal position. So whatever qualification is applicable for the junior assistant under the district establishment will have to be applicable to the present petitioner.
But the problem arises with your department. Your department seems to be not interested in coming up with more clarity, in spite of so many opportunities being given by me.
Here, but one thing, there is not a single whisper in this particular circular that this 1967 rule has been adopted. Moment that word adoption comes, then every amendment will have to be adopted. There is established rule of the apex on our Supreme Court. That law has been laid down. But we have only clarified that in the absence of the rule, this is a general rule, which will have to be followed. And in 1999, since the qualification was same, that only matriculation. That has been mentioned here. It's not that now, whenever there is amendment, we'll have to give a new notification. More particularly,
As
there is
per
adoption.
you, the circular only says that as we don't have any executive instructions or any rules, kindly follow the principles there.
Would come to the commissioner with all this representation. It is a
So that
district
is it.
authority, your head of the authority.
So now, therefore, you say, you can very well now come up.
Yes, yes.
Matter ends. Chalo, let me dismiss.
My submission, there is only question whether.
Now tell me. Now tell me, Mr. Sahu, you appeared on the last occasion when the writ petition was disposed of.
Yes.
Why you could not bring on this circular before me? Because this circular was never placed.
No, this circular was there, Miller.
Writ?
Yes, yes. Yes.
So-
On the basis of that I have.
In fact, Lordship has
On the basis of that I have. My case was the basis of my case was that circular.
So your case was based on that circular? And what did I say about that?
But actually on the day I raised these questions, this submission, and it was rejected because that circular speaks about LDA and promotion was in respect of junior assistant. That is why that was not taken into consideration.
By appreciating it would be relevant to take note of the brief facts. The petitioner herein has eliminated thereupon the So you did not submit on the question of legislation by incorporation.
We get not just not because the circular speaks about LDA and post to which the petitioner was to be promoted, it speaks about junior assistant.
So you say that you have submitted.
Yes.
And I did not consider it.
Only because of that.
If I did not consider it, then can you again make again a submission by way of a review?
The error, what I want to point out, my lord, although it was written in the as LDA, but it should have been junior assistant. Because of my lord,
No, it's everything is done. But if you have made the submission and I did not consider it or did not incorporate it, wouldn't it by the principles of constructive res judicata deemed to have been rejected? And if it is rejected, isn't it a case of an appeal? Not a review.
maybe, but without the ground on which it was not incorporated. It was because it speaks about LDA and the post in which he was to be promoted, it was junior assistant, only on that ground, my lord.
And there is not a single minute statement in my lord, some observation in this my lord, with that. To that effect. I don't think so, my lord, that was the ground. Only ground considered was that, my lord, in the amended, now subsequent amendment, the qualification is degree.
Your case is You have a degree, no degree. He,
No, he is higher secondary. I am matriculation.
now if it is not applicable, it is not, it is just taken as the spirit is to be followed. This is what Mr. B. Gogoi submits. It is the spirit of the ministerial rules which is to be followed. Then can Rule 6.6, which stipulates that the requirement of forget about the legislation by incorporation, be strictly enforced when you have not done so? Or can this court ask you to strictly enforce it, as it is the power is with you?
That's not, that I will have to give some kind of clarification. Some, some circular. There was one of the, if the spirit is followed, then automatically when the amendment is made, that was, in fact, that was the argument made, my lord, at the time when the repetition was followed. Since, my lord, we have followed the spirit, or we have clarified by the circular that this is the general rule which will have to be followed by the district authorities, while, my lord, filling up the post of junior assistant.
But understood very well.
Now,
But the question is, can this court enforce Rule 6.6
yes,
when your submission is that we strictly don't follow?
that part, of course, my lord, yes.
Don't you think that there is an error apparent?
That's why in our affidavit in the review, we have stated that, yes, we were following, my lord, relation as the, my lord, or it's SSLC as the call it. But so there was a doubt. Now, after this order, very clear, very clear.
No. Therefore, can this court impose upon a department when the power is strictly reserved, and that being not an issue, that you are to follow 6.6 in a strict sense?
In that case, my lord, the base course, my lord, which I find now, my lord, after that, my lord, lordship will refer this matter to the authority. Let them take a call, whether it will be class 10 first, or the matriculation, or the graduation as per the amendment. Whether 1999 will be followed, or this particular amendment which has come up in 2015. Since this particular promotion is after 2015, which will be followed, let the authority decide, including the government.
No.
And, my lord, That case, my lord, that clarity they will now.
I think what is required is I should review and recall that order and fix the repetition for this, for a final.
That case, my lord, that order can be.
I think that is the best way, because whatever may be, if your submission is categorical to the affair, that we have not adopted it, but only the principle, the spirit of that is to be followed. This court could not have nullified the petition or the contentions of the petition on the basis of a rule which you yourself say only the spirit is to be followed.
In fact, my lord, there was a direction passed in a similar issue, my lord, relating to the Commissioner of Taxes. This honorable court referred the matter back to the authorities. There they have, my lord, passed a speaking order. My lord, rejecting the similar claim made by, my lord, a person who is just, who is higher secondary or class 12 pass or class 10.
No, but
over.
that is an
But-
order to be passed in a writ.
Yes, yes. In the writ petition, it has been clarified, but in the speaking.
Now
order, it
what
has
will
been clarified.
happen? Now what will happen? Once I review it, his reversion goes back.
That will have to be, yes.
He again come back to the position of the peon, of the judicial assistant,
Yes.
or junior assistant. He comes back.
Maybe dismiss it, okay?
Which-
Because I just wanted to bring on record those two principles. Lord.
Now, the moment I review it, then in that regard, don't you think that he will revert back? His petition, I need not, I can dismiss it right away, that whatever may be, he was junior. If it is accepted, that rule is also accepted, then also it can be rejected. I can reject it on the ground that he was junior. And as such, his termination was, or his reversion was right. His review petition can be done with that. There's no problem with that. But as your review petition, if I do it, I'll have to review it. The moment I review, he reverts back.
My part, not his part.
No.
Why against one order?
Order has to be reviewed.
I have
I have to recall my order. The moment I recall my order, he comes back.
partial recall maybe.
No, there's no partial recall. How can there be a partial? There cannot be a partial recall of a review order. The order has to be reviewed in total. And then I have to fix the matter for hearing.
Then you can raise
That's the
everything.
process, how it is to be done. Then the question arises, he gets back wages here also. The moment I review, he gets restitution of his salary. What to do?
Police permissible or
There's no partial recall.
two parts area. One part is, my part is rejected. Thereafter, he was demoted. So parts area.
No,
I have
one
to-
part is your dismissal of your thing on the ground of 6-6.
Yes,
The second part is applying the 6-6 reversion of him.
on that count until, yes, that I understand.
So the moment I do that, in your case, his case goes, he becomes reverted back. Let him enjoy being the junior assistant for another 5-6 years.
My purpose was to bring those and to go
Huh?
and to go division bench.
Then you should have. You have gone to the division bench.
Because my submission was not.
Huh?
My submission were not on record. And in the meantime, he has filed the review. That is why I have to file.
He filed the first review.
Yes, that is why.
He says that it is not required, that a degree is not required. But if degree is not required, you get it. How to tackle this situation?
Peculiar situation. Peculiar situation.
Ah.
Then in the division, then same issue will come up. We review and the lordship will hear both the parties because on the last occasion.
And the moment I review, I have to also dispose of, otherwise he gets the benefit of that.
Things may not work for this particular tenure. That issue can be kept.
Hmm?
It not work, man. As a.
Who? No, he has not worked, it's okay, but he gets reverted back,
But he will get the status. Till the
which requires again a disposal.
yes,
Because the
repetition
moment I
will
do
have-
that, the repetition goes outside my clutches. Remember,
Yes, fine.
it goes outside my clutches. The once it is goes outside my clutches, then you never know when it will be disposed of. Because I don't have the roster.
One condition, his promotion can be kept in abeyance because
How?
whether he
He was
succeeds,
already promoted.
whether I succeed or I fail, consequence is that he will not get promotion. Even if I become success, he will not get, even I fail, he will not get.
We do one thing. We'll have it on Thursday next. Again, top of the list. Pass the order. But let me think what is to be done. So, can I take up both together? Normally, review jurisdiction, either, that is why I asked you, why didn't you bring it? If I don't exercise my review jurisdiction, it's okay. I don't touch the review. But that is on the exercise of the jurisdiction. But if I exercise the review jurisdiction, recall it, then I can't take up the review. And the moment I recall it, I can't partly recall it. Although there are many judgments where the review is being made on together. Review, read, everything is decided together, but that's not the principle. Principle is first you review, recall, and then a rehearing.
That will come only if in the interim stage, some review is filed. Petition is pending in that case, it is taken up together. But
Ah.
once disposed of, there is the existence of the repetition. They attend final.
The repetition will spring up, na?
But regarding the seniority part, in the review, we have filed the affidavit, we have brought it on record. So that part can be decided. That observation, if at all lordship disposes.
That he is not senior.
That can be from our affidavit, considering their reply, that can be decided by the honorable. Some observation can be made, but because that issue is now before his honorable court in the review.
No,
This
but
was not there at that point of time.
how do you take care of if 6.6 is not to be applied? That is why I gave you so much of opportunity to bring on record, come up with one notification, something that we are adopting 6.6.
Subsequent now, we issuing the notification whether it will cover.
Why not?
Let me.
If you are bring in, why not? Because earlier it is different. Because you see, I would have understood. The petitioner, he was reverted. Then I could not. Because his right had accrued on that.
Understand.
But he is not the question who he is the petitioner, no? He's the respond number 5, who was admittedly junior. So under such circumstances, his right would have been different. Hello, let me take it up again on Thursday. Please the matter on Thursday.
This Thursday or next?
This Thursday? Or at the top of the list. Just think.
Can bring the source.
First part, that's speaking order.
No, source or no source. Not required. From his own submission, one thing is very clear, that the spirit of the ministerial rules is being applied. Now, if the spirit of the ministerial rules is being applied, they may do how it is. But they themselves have not adopted that. It is only during the course of the hearing he came up with 6.6. And this court enforced it by disorder. Gave a stamp of authority, yes, 6.6 will be applicable. Although they have not done in terms with 166. This is the
Yeah, in
small,
fact, my lord, the promotion was done, my lord, following 99 circular.
yeah. They followed 99, therefore you ought to have got it.
It was my-
But he cannot, my lord, because he is not, he doesn't have the, my lord, graduation. So he doesn't have the graduation, my lord, qualification.
Understood, but as of now, you do not. You have till date not come up with a clear thing. You say that as the High Court have said now, therefore, we now follow the ministerial rules by way of an affidavit, not even by under exercising powers under 166.
Lordship.
Oh, we can do one thing, set aside, review this order and hold it that yes, he's AI, he's junior, he could not have been taken into consideration. The AI should have taken into consideration properly, and having not done so, they will hold it in accordance with law.
That's why, in the review, that order can be passed. Instead
Now,
of,
if
my
I
lord,
pass that order, then I think that is okay.
then
We'll
also
pass
we
it
will
on.
take a call, my lord.
We'll pass it on. Yeah.
My lord.
Just give me a thought
Okay.
how it is to be done. Being from the civil side, I am very specific about my procedure. This is how it is.
Otherwise, even if we are not use it, repetition can be taken with your lordship by doing it part.
No. That I can't do.
That will, in that case, it will have to be listed once at least. Put it on.
Because I don't have the roster for that.
Right.
I can't make a I cannot make a proceeding a writ which is not which the because that as of now that writ petition is not in existence. If it is not in existence, how can any I take it? So I have to delete both, dispose of both together.
In a review petition, it can be, my lord, new order can be passed, and that will be the final order. Considering the new facts that has now been, my lord, propped up, which was earlier it was also there in the petition. Now it has propped up. The lordship can, my lord, very well pass the
Let me think.
final
about
order in the review petition.
I think the best order would be to review it because the one thing which is affecting this court is this court could not have imposed upon the department to take 6-6 unless the department did it on its own. Because if I do it, it would be transgressing on the powers of the department under 166. Although I don't think that the circular has any value. For me, the circular doesn't have any value because that circular. You see, one has to understand that the commissioner could not have issued those type of circulars unless he had been given some power to do. And this is a sub-delegation, not a delegation, sub-delegation. It had to be issued on tomorrow on Wednesday, Thursday, top of the list. Yes, who wants to be impleaded?
Now, where I want in my lord 2280, my lord. IA 2280,
Two?
2280, my lord.
Yes.
But I want to implement Guwahati Municipal Corporation as a party respondent. Because I am a business establishment, I am running my business with the trade license of the, given by the municipal corporation. So I wanted them to be a party, my lord, as respondent number 6.
You are the petitioner
Petition.
and the next
Next, my
2195
lord,
is
I have filed this.
my lord, next I have filed an objection yesterday.
2195.
My lord,
what?
objection against their implement because my lord, he was first appearing for respondent number 5, Guwahati Kabarstan Committee. My lord, then my lord, another council appeared for respondent number 5 and said that they don't have any existence because they have resigned on 2021. And thereafter their membership has also been taken away. So, but previously they appeared for respondent number 5. Now, when they found that they are in trouble water, so they brought in some masjid committee who has no related with this case.
Completely wrong submission, Lordship. Completely wrong submission.
I have made my objection to that, my lord. Now they want
Okay,
to.
okay, wait. Who is 2280?
280, I am the petitioner who want to make.
What is your case?
My case is, my lord, that we are the tenants under the Guwahati Corporation Committee, but they have filed an affidavit stating that we are the tenants and there is a suit pending and injunction going on there, that I should remain over there. Then somebody find
What
it,
order do you want in the writ petition?
my lord, because there is one
Writ of
PLP
certiorari should not be issued, setting aside the interim notices issued by
Notices that are in
respondent number
page
4 asking the
4, your
owner
lordship.
to vacate the land of the cover. Writ of mandamus should not be issued directing to allow. Why are you making the state Guwahati Municipal Corporation as a
Because, my
part?
lord, there was an objection raised that we are running a business establishment on the basis of a trade license issued by the Guwahati Municipal.
So what?
So, my lord, I thought it was
So
necessary.
you don't think because your case is against some Koborstan.
No, Purpose
Who is
that they are
appearing for the
supporting,
Koborstan?
my lord.
And isn't this a purely a civil dispute?
No, my lord, PLPC has issued an order at page 224, your lordship will find.
224?
224 of the writ petition. Encroachment notice against which we have come, my lord.
Who has issued?
My lord, he is issued by Circle Officer Guwahati Revenue.
So hereby informed that it is covered by so and so. Now, this is against the government.
Against the one. Government raised the question that you are running a shop on the basis of trade licenses, so why don't you have made a municipal corporation apart?
No municipality. What do you say, Mr. Nayak? You may like yourself to be a party. No, why? Do you have any business out there in this matter? Nothing.
As a
Here, some notices have been issued which have been put to challenge. By whom? The circle officer.
revenue authority.
Then,
I remember.
why have you issued notice, circle officer?
There is a reserve plan for the corporation, which was enclosed by the some of the petition enclosed.
18-2. These are notices under
18
They will take action under 18.2.
18-2. Oh, issue notice 18-2. And then let them reply as per the new
But that
judgment.
was the question, my lord. My lord, on this-
Nothing, matter ends.
My lord, I
Why
understand,
we
my lord.
all these missed cases unnecessary?
My lord, if your
Matter
lordship
there.
permits- My lord, I understand on the basis of the
Matter
Salakuddin case, my lord.
finish.
My lord, your lordship, my lord, they have issued a notice without hearing us.
Which notice?
This notice has been issued without hearing us.
Hurry.
This 18.
You are otherwise necessary action will be going. Go and file a reply.
My lord, we filed a reply.
Where?
That we are the tenants. My lord, your lordship will find the minutes of the PLPC committee.
Huh?
The minutes, my lord. Your
Where?
lordship, you may
No, after the notice, where?
at page, your lordship will find 214. Minutes of the PLPC committee.
2-1.
214, annexure 10.
This happened previous.
Previous to the notice. my
No. After the notice, why haven't you replied?
lord.
Go there. Nothing doing. Nothing.
Your
doing.
lordship may dispose of that after hearing both of us, after giving.
No hearing. You will submit your reply. They will look into it.
That is, my lord.
Nothing more.
Your lordship
My
may do it. that-
goodness. Thanks.
Because my lord, the government, before issuing a notice, gave us a hearing which was not proper in 214. Because it was sent by the division bench, go to the PLPC, my lord, and they will, after giving a hearing, they will dispose of the matter. The order is from the division bench. Your lordship may look into the order of the division bench, my lord. That is at page.
Enforcement notice was issued after hearing what the parties by the lordship PLPC.
Well, they are no have,
PLPC
no
forwarded
request to
like-
argue.
Why not local? I am replying responding number 5.
No.
I have filed my objection also. Why are you saying like this?
My lord, respond number
I
5.
have my own objection also.
Mr. Count.
Regarding my status, lordship, it's not fair also in court.
My lord,
Not
respond
fair,
number- somebody.
Fair. You have filed an I.
No lordship.
Whose I it is?
I have filed, but
Wait. 2195 is whose I?
it's filed by one of my client, lordship, representing this person, yes. Yes,
Is this
And-
application allowed?
no lordship.
Am I,
Prior to that, I have-
Mr. Counsel, am I taking up this application now? Am I?
no lordship.
Then
I am repeating repetition laws.
go absolutely further down there, bring Mr.
No, Lord, I am
Dharam.
repeating response number 5 of repetition.
I'm not asking anything. Here is a notice has been issued by the circle officer.
Yes, Lord.
The circle officer has issued a report, notice, they will make a reply within 10 days, 15 days. Thereafter, you take a decision as to whether they have a bona fide claim or right involved.
My lord,
Do
that's
whatever
fine.
you
On the basis of
I'm no
Salama,
business on.
para 28 on. Or should may dispose of.
It's purely a civil dispute.
Because my lord,
And if you have anything with the Koborstan, why you're not going before the Koborstan?
the Commercial Committee is represented
I
by
am
Mr.
repeating
Thor.
this.
My lord,
He's putting-
Why you are not going before the civil court?
there is a dispute going before the civil court. There is an injunction order.
Very well, go there.
But the PLPC, on the basis of a division bench, somebody find a PIL. On the basis of a division bench, the PLPC asked both the parties to appear. The Kobostan committee, my lord, could not appear because there is an injunction between the two committees. That is why,
You say that you are tenants under the Koborstan.
my lord, and they admit to it.
Whether they admit, I'm not concerned. You say that you are tenants of the Koborstan, you have filed some suits against them.
The injunction order.
Injunction orders are here.
Yes, my lord, I have,
Where?
the lordship will annex. My lord, 146. My lord, the status. My lord, page 150, your lordship find. So we are therefore restrained from disturbing the position of the suit premises by the petitioner in many a manner in the disposal of the suit.
Some of these are there.
Only one. Lord.
Well, the different suits are there. I have given
Only
one
one
copy.
section.
There are many tenants under them, madam, and all are filed suit. Not possible to annex all the other copies. I have annexed one such copy. 139, your lordship will find another.
Okay, 2280. Is an application filed for impleading the Guwahati Municipal Corporation as the respondent number 6 to the accompanying application petition. This court have duly perused the materials on the writ petition, and from a perusal thereof, nothing could be seen which would justify that the respondent, the opposite party number 6, that is the Guwahati Municipal Corporation, is either a necessary or even a proper party to the instant proceedings. Accordingly, this court finds no merit in the instant application, for which the application stands dismissed. Heard Mr. P.K. Roy Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. A. Hendik appears on behalf of,
2, 3 and 4.
who is revenue? Mr. A. Bhattacharjee appears on behalf of the revenue department. Mr. J. Hendik appears on behalf of the rest 2, 3, and 4. Who appears for 5?
I am-
Mr. A. Dhar appears
Lordship,
on
I am
behalf
repeating
of.
response number 5. Lordship, I am repeating response number 5. Lordship.
Why did you file this application?
No, Lord, this is different issue, Lordship. Lordship, that is why Lordship I am saying. In a
You have signed the
repetition-
Wakalatnama
Yes.
for response number 5,
Lordship, I have filed affidavit in opposition also.
My lord,
In read petition,
and Mr. Dhar.
they have not filed.
Full stop. Yeah. We have response number 2, 3, 4. Full stop. There is a dispute amongst the two councils, Mr. J. Kolita, A or J?
J.
J. Kolita, and Mr. A. Dhar, as to who would represent the respondent number 5. First. However, this court would not like to go into the said dispute, taking into account the lists involved herein. It is seen that the petitioners herein claim to be tenants under the respondent number 5 and and are running various business establishments in the said land. However, pursuant to a meeting held on 11/3/2024, the petitioner, meeting held on 11/3/2024, with the office of who are these people who are present?
My lord, I filed an application also there.
No, were you present?
My lord, I was present, my lord, we have submitted documents also.
Where is your present? Name not present.
My lord, your lordship will.
Parijat Bhuiyan, Sanjeev Dalal, Ajit Kumar Sharma, Raja Boishya.
These are the members of the PLPC committee.
Huh?
They are the members of the PLPC committee.
You, where are you?
My lord, the meeting is presented, discussion of the meeting, next page, my lord.
Where?
Page 215.
If 212 we finishes it, after meeting. In GMC trade license does he rightly say. দেখুন কি লিখলে তো? Held on 11/3/2024, certain notices have been issued to all the petitioners, which have been enclosed collectively as Annexure 12 series to the writ petition. This court have duly perused the said notices, whereby the petitioners herein were informed that they have encroached the government land covered by dark numbers 2143, 2144, and 1984 under Moza Guwahati, Sohor Guwahati Part 1 by running business/constructing shop. The petitioners therefore were directed by respective notices to vacate the land within 15 days from the date of receipt of the notice. It was also directed that in the circumstance the petitioners do not vacate, action will be taken under Rule 18(2) of the settlement rules under the Assam Land and Revenue Regulation 1886. The petitioners thereupon have approached this court by filing the instant writ petition. The basic ground on which the instant writ petition has been filed, that the petitioners are tenants under the respondent number 5, and as such, they cannot be evicted in the manner which is being sought to be done by the revenue authorities. This court have duly taken note of the recent judgment of the division bench of this court in the case of so-and-so versus so-and-so.
Salakuddin, WPC 1057/2022. WPC 1057/2022, judgment passed on, my lord, 27/6/2024.
Name.
Mr. Mohammad Salakuddin versus State of Assam. I'm submitting a copy now.
Ahmad?
Salakuddin. I have submitted a copy. There are 28 onwards.
A recent judgment of the division bench in the case of MD dot Haq versus the state of Assam, others, reported in 2024 SCC Online SC GAU 921. Wherein the division bench of this court
The 28 man.
held that the person to whom a notice is issued under Rule 18.2 of the settlement rules under the Assam Land and Revenue Regulation 1886 would have a right to place before the revenue authorities that they have a bona fide claim of right involved. This court is of the opinion that the petitioners herein, instead of approaching this court by filing the instant writ petition, ought to have approached the concerned revenue authority who have issued the notices as to the effect that they have a bona fide claim of right involved. Basing upon the said, under such circumstances, this court is not inclined to entertain the instant writ petition. However, grants 15 days from today to the petitioners to submit their representations before the circle officer or before the authority who issued the notices which have been impugned in the instant proceedings by submitting respective representations as to if they have any bona fide claim of right involved. The respondent authorities shall, on the basis of the said representation and taking into account the observations so made by the division bench of this court in Salakuddin, Supra, at paragraph 29, 30. One. And thereupon, shall dispose of the said representations by taking note of the judgment of the division bench of this court in Muhammad Salakuddin Supra, by taking note of, and more particularly to the observations made in paragraph 29, 30, 31 of the said judgment.
The interim order will continue to.
Huh?
The interim order will continue to.
What interim order?
Because otherwise, if they may evict us, because there is an interim order,
What interim order?
not to disturb our operation. There is an
Till such disposal, it is that till such disposal by the concerned revenue authorities, no measures shall be taken against the petitioners.
one more prayer. As long, we will file our observations or representations. One of the Consultancy committee, respondent number 5 will also file the representation. because-
Why?
Because they,
Absolutely no. Is there any notice to them?
My lord.
Is there any notice to them?
they were asked to appear.
No. That is a different thing. Is there any notice to them to evict?
What's in my lord?
Mr. P.K. Roy Chandleri, don't.
PLPC already my lord decided. That co-
Eh?
I did my lord that delegate. Any already been decided, my lord, that copy.
To whom? PLP has decided?
That I have shown your lordship earlier, that they are going for that, my lord. That minutes that I have said, my lord. The eviction notice were issued on the basis of the minutes when the Consultancy committee and the petitioner approached on the basis of a division bench order. Going on the basis of a division bench order, we approached the PLPC. Then the Consultancy committee said, because we have put them as a tenant more than 40 years ago, because the Consultancy committee is run by the tenant rent that are paid to us, because government does not give us anything. That was the statement of the Consultancy committee. Then the PLPC asked the Consultancy committee, where from your right acquired that you've given them as a rent?
Mr. Chaudhary, if it is a land allotted to the Koborstan,
My lord,
Yes.
Consultancy
allotted to the Koborstan committee,
committee.
a different aspect of the matter, then it does not become the government land.
That is that. That is the issue.
No, it doesn't become the government land. And as such, the government can't issue notice. But if it is, in addition to that, the petitioners would also be at liberty to raise the issue as to whether the land upon in respect of which the notices have been issued are government lands.
I may withdraw this.
What?
2195. I
Withdraw. Mr. So-and-so withdraws their application. That he would not like to press the, in view of the proposal of the petition. Accordingly, the same stands here. Very.
Obliged. It is my lord.
Barbujari, kindly tell whoever was appearing for that circle officer and all, the order which I just passed would be a bit different. Not that it will be them to sending it there, but there will also be mention of government land or not, which also. Yes, Mr. Bachchan.
Kindly peruse this instruction.
What happened?
My lord, we have not received the input yet.
Everything was finalized, my lord. Now, only my lord, with regard to that quantum of my lord, land acquisition compensation, it is yet to be deposited, my lord, by the authorities in the medical department. But more particularly, Director of Medical Education was requested to deposit the fund immediately so and so, along with capitalized government land revenue so and so, amounting to rupees 63 lakhs. That is total 11 crores 14 lakhs 30,542 in favor of in the first phase to enable this office to disburse concerned porters involved in such.
So notification under section 6
Yes, Section
already
6
done.
have been issued, but it has not been provided to me. That lordship will find that my lord clause A, my lord, the first paragraph itself.
It says that notification under section 6 has been issued,
Issued.
meaning thereby the land has been acquired.
Acquired. Now, once the amount is deposited, it flows, it is released to the petitioner, then immediately the award will be passed.
Yes, when?
The director has moved the government, madam. Director has moved the government in the health department. That sanction and all will, sometime, madam, I can have the specific instruction.
And
Madam, let it be on Friday, madam. Or
so
Thursday.
the interest is accumulated.
I understand, madam. So about 11 crores
11 crores.
and interest will be at the rate of 12%.
Interest will be 12% because they will.
How
get
much
like-
they are going to get?
They will be, my lord, getting an amount of rupees, my lord, 34 lakhs. What's the table? My lord, they will get 10 crores, 10 crores, 50 lakhs. 10 crores, 50 lakhs, that lordship will find at paragraph B, the last line. Yeah, sure. Because the total quantum of land, my lord, is 6 bigha, 4 kotha, 14 lessas, out of which, my lord,
Total land is 34 crores.
Yeah.
Of which the share of the petitioner would be 10 crores 50 lakhs.
yes,
What about the other people? Or not before it's court?
they are not before this honorable court. But nonetheless, my lord, since the quantum of land is a, my lord, wholesome land, so therefore we cannot, my lord, segregate it, my lord, for the purpose of land acquisition authorities. It is only pursuant to my lord's strictures issued from time to time that the authorities have now swung into action. And this has, till this position, it has been progress.
No, when are you passing the award?
Award, my lord, I am told that, my lord, since now section 6 notification, since it has been issued. And the rate of compensation has been negotiated with the petitioners. Rate of compensation has been as per negotiation made with the petitioners.
You're
Yeah.
taking under the Assam Mala project,
Not as a Mala project, it is a negotiated, my lord,
the consent award.
consent, the consent. Will be a consent, because pursuant to my lord's direction, the petitioners had.
This will be an award in terms of section 12(2) of the Land Acquisition Act 1894,
Yes, it will attend that character.
consent award.
Yes. But the factum is that only the petitioners are before this honorable court. So far as, my lord, land measuring 2 bigha, 10 lessa is concerned. Now rest of the land, it will be kept in revenue deposit. Once persons, my lord, approach.
The persons have to be informed.
One notice at one.
Since, my
Because
lord,
why are you asking therefore only 10 crores from them? But later on, what will the other persons should again come to this court?
definitely, but because since this lease is pending, my lord, since this lease is pending, it is not that we are asking 10 crores. We have asked, my lord, for the entire amount. But since this lease is pending, my lord, so therefore.
No,
we have-
understood, but this is only one, the petitioners.
No,
But
they are.
overall, you see, in the question of other is not that. The only thing is, see, the interest is phenomenal, which is going to go up.
Absolutely. So
Any
therefore,
delay, the interest is phenomenal. Here the petitioner is there, it's okay. For him, he will get it. That they are then, if you keep on delaying, there will be interest.
now to that extent, my lordship will kindly see the last paragraph. Accordingly, the Director of Medical Education was requested to deposit the fund immediately amounting to so and so, along with capitalized value and so and contingency amounting so and so, total 11 crore in favor of, in first phase, to enable this office
No,
to.
this statement is wrong. See, what you are doing is, you have already come to a negotiated settlement. So 1033 is in respect to the period from the date of the notification to the date of the award.
Yes,
That is 12%.
yes,
But the possession is with you. So it will be 9 and 15.
10 and 15.
How do you take care of that? This is a huge amount which is coming.
So they are doing it, my lord.
Arbor Pujari, the Learned Counsel appearing on behalf of the Revenue Department of the Government of Assam, have placed before this court an instruction issued by the Additional District Commissioner in charge Land Acquisition Branch dated 5/8/2024, whereby the land whereby the total acquisition cost of the land measuring 6 bighas, 4 katha, 14 lechas have been ascertained as rupees 36 lakhs 79,050, 36 crores 79 lakhs 50,542. Out of the same, in respect to the claim of the petitioners, which pertains to 2 bighas, 0 katha, 10 lechas, the entitlement would be rupees 10 crores 50 lakhs. Accordingly, requests have been made to the Director of Medical Education for depositing the said amount along with other expenses totaling to rupees 11 crores 14 lakhs 30,542. He submits that the said amount have not yet been deposited by the Director of Medical Education. The said instruction is kept on record and marked with the letter T2. Full stop. Mr. B. Gogoi, appearing on behalf of the Director of Medical Education, submits that he may be given some time for getting the instructions. List the matter again on, have it on 12th? 12th of August 2024, on which date an update shall be given by the council appearing on behalf of the Director of Medical Education.
I move like.
Item I.
Letter of intent was issued to the petitioner, which I am representing in 2019 for setting up a Shell retail outlet petrol pump at page 28 in 2019. Now, my lord, all the regulation all was followed. We came up before this court because of page 34. Kindly say page 34. We was informed by the Gaupura also, and a drawing was provided to us at page 34. That this is the on the right hand side, this is our petrol pump, AK Das and Sons petrol pump. And the proposed petrol pump, which it is given to my learned friend, it is, this is your lordship proposed geo petrol pump. Now, my lord, as per the guideline, there is a statutory force as per the guideline that you have to maintain 1,000 meter as per the guideline, and they have not maintained it. And
Guideline of whose?
these guidelines between two petrol pumps,
Guideline of whose?
guidelines of the Ministry of Road Transport and Highways. At page, my lord will kindly see at page 35. Page 35, that's our whole case.
This is old.
Oh, that's
Nowadays you
20.
find the 2-3 petrol pumps
No.
together.
2021 also we have annexed. 2020
Where?
at page 48. Page 48. We kindly see at page 60, my lord.
48. What is?
48 is the guideline. What you got it? 26th of June 2020. My lord will kindly see at page 60.
Page
Page 60, 60.
60.
Yes. 2.2. 60, 2.2.
Yes.
Location norms on rural stretches on national highway. My lord. 6. Distance between two fuel stations. Undivided carriageway 300 meters. Divided carriageway 1000 meters. This is a divided carriage. 1000 meter you have to maintain. Now, my lord, there is again, if a lordship, however, my lord, kindly see that, however, the restriction shall not apply. Restriction shall not apply. Say, in case excess egress for all such fuel stations are provided through common service road of so and so with and not directly to so and so. If there is a common service lane, then even then when there is no question of, if you don't maintain also, you can put to petrol pump. In my lord, if it is they make a service lane. And if they maintain this, we, my lord, we have nothing to say, my lord, in this case. Now it is admitted position by the National Highway also that this particular, they have no service lane is there. There is no service lane and they want to put a petrol pump, my lord, which is less than 1,000 meters. That's
Who?
our case.
Theo,
If they maintain, well, I have no, we will withdraw it. There is absolutely no.
maintain what? One.
They have to maintain that meters, 1,000 meters, which apparently they are not maintaining. That's a, they want to put a petrol pump. Kindly see the drawing, Milo, once again, Milo. At page 34, Milo.
Petrol pump is given by whom? So what authority?
Yes. My lord, the authority is the, you have to apply before the authority can, if it is IOC, you have to apply before them.
Understood, but
But
IOC can,
with setting up,
can
if it's a
IOCL or
national highway,
anybody
if
have
it-
a rampant petrol pump everywhere?
So if it's a highway, if it's a highway, national highway, then for setting up of a petrol pump, you have to take permission from the National Highway Authority.
Where is it?
This is under here, my lord. NOC has to be taken.
Where?
In their affidavit also, they have said, my lord, by the National Highway Authority most.
National Highway has filed a affidavit.
Yeah, they have filed an affidavit. Kindly see the affidavit, my lord. This starts from page 88. Paragraph 11, 14 and 15. Kindly see 11, my lord. '95. Last 5 lines.
The respondent who was 7. This is filed by
By
Soidul
the National
Islam.
Highway
Who is he?
Authority.
No, he is for 7.
Yes.
7 is the owner of the
No,
petrol
no,
pump.
my lord, affidavit in opposition by the National Highway Authority.
Where?
Response number
Page?
3, my lord.
Page,
Response number 3.
page.
Page, it starts from page 88. Your lordship,
No, 88 is different. Is filed by by the response number 7.
but they must
Affidavit in
provide it.
opposition
Copy.
filed by response. There is only one affidavit in opposition filed by response number 7.
I think my learned friend, my lord, has filed. They have filed. He has given a copy to us.
Here, my lord,
My lord, I don't know whether your lordship has to have that, otherwise
88,
not possible.
in according to us, it is starting from
I think it was
88.
there, my lord.
88,
I don't know whether.
Not there.
chapter number 3, my lord. Lordship.
I don't have a copy.
Computer must have 9 and 5. I have 5 days.
I got an extra copy, anybody?
Yes, it did not.
So, but I have marked it, my lord, please don't think.
But issue here, my lord, actually, before going done, when petrol pumps আমার সেগুলো এখন করেছে দেখুন মুভ টু 91 করে দিয়েছে 28 করে দিয়েছে তোমার লোক
Lordship, kindly see para 14 and 15.
he heard
Yes.
Okay.
Mr. C. Burwa, what do you have to say?
here, my lord. That's it is whenever petrol pumps are stalled near national highways. Here's the guideline, my lord, as my learned senior has already pointed out. Here, what happened, my lord? Initially, পেন্ডিং হৈছে 104
Who is this Raja Das, Senior General Manager, Reliance BP Mobility? You.
I'm a,
So what is your stand?
my lord,
You are going to give an undertaking.
yes, yes. We are,
So you mean to say that without compliance with this undertaking, which has been given by Mr. Raja Das, you shall not proceed with the mobilization of that particular, yeah?
we have given undertaking to construct a, my lord, road, service road for 7 meter wide. I have given that map also there, lordship. You'll find it.
Where?
Lordship, first, lordship may see page 31, matter my IA, my lord,
To file an IA.
vacating application. Lordship may come to first matter, page 31, my lord. Clause 4.6.3.
Yes.
They are
4 point-
coming at page 34, 4.6.1. So there is an exception, my lord. If two, my read, my lord. 4.6.3, if two or more fuel stations are to be sited in close
4
proximity.
point?
4.6.3, page 31. my lord.
6.3. If two or more fields.
If two or more fuel stations are to be sited in close proximity, for some reasons, these would be grouped together to have common access through a service road of 7 meter width and connected to the highway through acceleration deceleration lanes. From these consideration, the permission for the new fuel stations would be considered only if it is either in proximity to the existing one, so that the common access can be provided, or new one located at a distance of more than 1,000 meters. Any objection from existing fuel station owner against granting of access permission from National Highway for the proposed new fuel stations are to be overruled, and access to all fuel stations in case clustering shall be invariably be from the service road only, wherever long service road exists, which may itself act as deceleration, acceleration lane, no separate deceleration, acceleration lane is required. So, my lord, there is an exception that if I construct, lordship may see the map I've given last page, my lord. Page, my lord, 52, my lord. These are the two petrol pump, my lord. One
Which
is
are the
mine
two?
and one is Shell company, my lord. Now, is road is, my lord, that 7 meter road, service road has been, we are construct at our own cost, my lord. And for which we have given an undertaking.
Which one is that? The other one? The petitioner's one?
Petition one on the right hand side, my lord, site for proposed retail outlet, my lord.
He is getting from Shell.
I am getting from Shell. you from
Shell
Reliance.
RO, retail outlet,
My
and
lord.
yours is the bigger one. So
My
you
lord,
have, you have shown it bigger.
My lord, we have said there is, my lord, what we said, we have objection. Let them construct the service. So there is a,
We are-
let them construct
we are
it. First they have
constructing,
to
my lord.
construct. Undertaking, they have to construct first.
We
They have not
cannot
constructed.
construct without permission of NH, my
Yes.
lord. We have, lordship may see page 38, my lord, for a moment.
We are not disputing that.
With the undertaking, my lord, at page 39, 38 and 39.
Yes. Is the undertaking. Now this undertaking, this paragraph number 1,
My lord,
page 40.
my lord,
Mr. Das, this
yes.
paragraph number 40 of the undertaking, page number 40 of his
It's
application.
undertaking. A type
Yeah.
copy is a 39, my lord.
It's okay. Now, if this is complied with, you have no objection. Yes, NHI?
But they have to construct, my lord. They will give.
No, it's okay.
Yes.
No,
your
no,
lordship
we
will find
make
them.
it
Your lordship.
that the permission would be given by NHI only subject to this being complied
Yes,
with.
correct, my lord.
That's
right,
all.
That's right. That's our whole case.
You have a look at that. You are okay with this particular being complied with, then you can give the permission.
Here, my lord, question is coming here, lordship. Now,
If you see at para 14, this undertaking has not been given to NHI itself.
here,
That's
my
what
lord,
that para
we
14
have
they
to,
indicate.
payment service should means this is to be continuous, not that only particular entry. Only here the question is coming only entry, my lord. Coming entry from the road concern and going. The service should means, my lord, which is generally parallel goes that route. On another route is those there. But here, lordship, if my learned friend is submitting on that he is the petitioner, actually what happened, Miller? Initially, in principle that word I also mean, we have given them permission. That means in principle, not NOC. But during that entry and exit, which was coming, that one had not been constructed by them. They took sufficient time. In the meantime, they have approached, might have approached, but we have not given so far in principle also NOC to them. That is also correct thing. Now, as matter has filed, my land has been this filed, this writ petition. Now we have clearly said due to pendency of this matter is sub judice. It is we are neither we are giving to him also NOC. Now in principle also we are not giving. He is in little step is ahead.
Now, are you okay with this undertaking?
Now that service should means I have to take instruction which manner it will be treated. That service should. Yeah, what is logic meaning? May I pay for only or Monday time?
Why don't we have already?
No, that's because service should means I have to get understood because I can say very well
No,
now.
no, whether this undertaking, if we dispose of the repetition with a observation,
No, that,
that, no, let me
yes,
tell
madam.
you,
Yes, ma'am.
with an observation that this particular undertaking, if duly complied with, then
what
only
requirement.
the NHAI shall give the necessary in principle or the NOC for the geo petrol pump to commence.
That can be.
Would that,
because
no, would that be sufficient, taking into account your guidelines?
That case may not, two words will be required here. As per requirement service should. That service should, as per requirement of National Highway Authority. That word is to come up.
No, therefore I'm saying, whether this
That is
undertaking,
that time.
Mr. Burwa, if
My-
this undertaking is there, which says that here will be provided a common service road of 7-meter width and 154-meter length between the two fuel stations to entry and exit for both the fuel station, also existing box culvert of 2 meters width will be extended on service road. Further, the cost of such service road and extended there be borne by so and so. This is what they are
This
saying.
is-
Whether this is in compliance with
Is why, my lord, now
clause
my
4.6.3.
my query before will be on National Highway Authority, 7 feet wide and 154-meter length it is. Whether it will be amounting to service route or this route should continue further. That is why that query has to come because that service route what manner. That is why only in the basis of instruction.
No, but your affidavit says different. Your affidavit is very clear. Kindly come to page 97 of your affidavit or internal page, whatever it is.
97, my lord.
97, you see, you see,
97, it is further.
it further stated that the aforesaid undertaking dated so-and-so by the Reliance Mobile has neither been directly given to NHI to get permission for access for their facility, nor the NHI has issued NOC to the Reliance BP Mobility Limited regarding opening of a new petrol pump in the land in question. It is replied that the NOC in principle from NHI has not been issued to the Reliance MEA till date in regard to setting up of the proposed petrol pump in such close vicinity of the petrol pump. Then before that, as such, BP, who was the intending to open the proposed petrol pump, has given a commitment to create a common service road of 7-meter width in connection the acceleration and acceleration lanes form clustering with additional land at the cost of the so and so signed by so and so. Now, whether this undertaking, first of all, how did you get the undertaking if it is not submitted to you? That is one thing. The second is whether this undertaking, if this is done, is it in compliance with, you have the IA,
My lord.
IA 4.6.3, page 31.
What's it, 4 point?
6.3. If two or more fuel stations are to be
Yes, I've got it.
sited in close proximity for some reasons, there would be grouped together to have a common access through a service road of 7-meter width and connected to the highway through acceleration, deceleration lanes. From these considerations, the permission for the new petrol fuel station would be considered only if it is either in proximity to the existing one, so that the common access can be provided, or a new one located at a distance more than 1,000 meters. Any objection from the existing fuel station owner against granting of access permission from NH for the proposed new fuel station are to be overruled, and access to all fuel station in case of clustering shall invariably be from the service road only. Wherever longer service road exists, which may itself act as the acceleration lane, no separate so and so is required. So if there is already there is no requirement. But otherwise, going in and exiting, you need a 7-meter road with road service lane.
That it can be undertaking if my learned.
No, it's okay, that's why.
Because he's
how
just a
can I
petitioner.
vote your-
No,
I
because-
No,
cannot-
therefore, we have it on Thursday. You get that instruction out there. Okay? Only to that effect. Whether this undertaking, if complied with, would
Whether-
that suffice?
whether-
Because your answer does not, your affidavit does not say so.
Yes, that was actually, even I feel this is a big affidavit.
Very
Well,
good.
my understanding. This is really, though I have prepared,
Yeah.
because instruction which is given me, actually that instruction was not given compliant, I also understood otherwise. Now, after going through all this, I have understood. That is, I have submitted this word Miller. They let me get one day timing.
Lordship may see
I
that
have very well said.
affidavit, my lord, para 11 is clear, my lord.
Now,
Para 11.
affidavit you, this one, Lordship has asked me to get instruction and
Para 11
undertaking,
is-
I'll take instruction, that's enough. Now, affidavit, as I am saying, that is a, myself is saying this is not a good affidavit, not bad, it's a good affidavit.
It's okay, but whether that would suffice as per them. Because you see, for the petitioner may be okay, but then also can I pass an order to that effect that they should give it on the basis of which will be the horse, the rules, the
Only
guidelines.
that time, Miller, Thursday, I'll bring your
fantastic.
lordship. Only
But
put
if
that,
Let me
lordship may
put
the
it
query
down.
that way.
You hear what I'm
But
writing?
only one.
Whatever
if I-
query is there, lordship put, I'll
But
clear
if
to all
I'm-
those queries.
If I'm not there also, my.
it's
only
okay.
Permission will be taken from the lordship.
No, it's okay. I'm putting down your submissions here.
Otherwise,
Mr.
my lord,
Didas.
what I'm going to lose, 2 or 3, 4, whatever. That doesn't lose anything, I'll get the benefit, but it
Or
should not go
Mr.
beyond that.
Didas, the learned senior counsel assisted by so and so, appearing on behalf of the petitioner. The Cibolua,
Appearing on behalf of
the
respondent
learned
T. Miller,
counsel
NACI.
appears on behalf of the respondent numbers.
3,
Only 3.
yes, Miller, National Highway Authority of India.
That's on behalf of the respondent number 3. And it's the Hero, the learned senior counsel appears on behalf of the respondent number 5 and 6. Who appears for 7? It's the longest of the name, AHMR Chaudhary. Appears on behalf of the respondent 7. The issue involved in the instant writ petition pertains to as to whether the respondent number 7, who is proposing to set up a retail outlet for distribution of petroleum products, should be permitted to set up its retail outlet within a distance less than 1,000 meters from the retail outlet already set up by the petitioner. Mr. Didas, the learned senior counsel, have referred to a diagram, have referred to a map enclosed as Annexure 3 to the writ petition, showing that the distance between the retail outlet of the petitioner with that of the proposed with the proposed retail outlet to be set up by the respondent number 7 is 203 meters. He submitted, drawing the attention of this court to the circular of the Ministry of Road Transport. Is it NHI or Road Transport?
Transport of
That is
highway.
Ministry of Road Transport. It is actually by Union of India. That is-
To the circular, to the guidelines issued by the Ministry of Road Transport and Highways, that the distance between two fuel stations in respect to undivided carriageway is 300 meters, whereas for divided carriageway is 1,000 meters. He submitted that there is an exception to the maintenance of the said distance. In a case where access oblique egress for all such fuel stations are provided through a common service road of 7.0 meters width and not directly to the national highway. In addition to that, access to the fuel stations at closer proximity than the distance so mentioned may be allowed provided entry oblique exit for both the fuel stations are provided through a service road of 7.0 meters width having sufficient length, comma, further, additional length of such service road shall be constructed at the cost of the later fuel station owner oblique company seeking grant of permission for access for the facility. The learned counsel appearing on senior counsel appearing on behalf of the petitioner submitted that without there being a 7.0 meter width road service link constructed by the respondent number 4, 5, and 4, 5, 6, and 7. 5, 6, and 7. He's there. 5, 6, and 7. The question of the Ministry of question of granting permission for setting up of the said petrol pump by the respondent number 7 does not arise. It is seen that an affidavit in opposition has been filed by the National Highway Authority of India. In the said affidavit, it has been mentioned that the NOC oblique in principle approval for NHAI has not been issued to the proposed Reliance BP Mobility Limited till date in regard to setting up of the said proposed petrol pump in such close vicinity of the petitioner's petrol pump, and in that regard, the project director, PIU-Bongaigaon, NHAI had written a letter dated 22/3/2024 to the regional officer, NHI RO, NE Guwahati, stating inter alia that the proposal for in principle approval of the retail outlet fuel station located on the left-hand side boundary of NH 27 towards increasing chainage in KM 1011.016 at village Helona Pam, Moza Hauli under the revenue circle Barnagar in the district of Buxa. And in that regard, a writ petition has been filed and the matter is sub judice on in principle approval and sub judice, and as such, the in principle approval may not be processed for approval till finalization of the court case. It has also been mentioned in the said affidavit that the respondent number 5 had given a commitment to create a service road to form clustering with additional land at the cost of the proposed Reliance BP Mobility Limited by the undertaking number 38AA-369942 dated 17/8/2023, signed by the Senior General Manager, Assam and Northeast State Office, Reliance BP Mobility Limited. Full stop. The said undertaking have been enclosed to the said affidavit. Full stop. The relevant portion of the said undertaking, being very pertinent, is reproduced herein under. Page. এখন এখনো আছে হ্যাঁ উন্নত আছে page 40. Plus, লেখা আছে, this to certify that reliance. Hey paragraph to, one. এটা কাম করো, hey undertaking. The said undertaking is reproduced here in under, গোটেইটো দি দিব, হলে ইয়াতো পাই যাব এইখন। এখন ফটোকপি এটা কৰি দি দিব, ঠিক আছে, নাই খনত আছে ভাল নহয় এইখন, আৰু এইখন ফাইলটো দিব লাগিব। Under such circumstances, in that regard, this court have also perused the affidavit in opposition filed by the respondent number 3. It is not clear from the said affidavit as to whether as per the respondent number 3, the undertaking so given is in consonance with clause 4.63.
6 point.
Of the this is an old one.
Notification that is dated, it's 12 April 2013.
No, you are going to an old one. Now they have a new one, na?
I have given a new one.
Where's the new one? Is in consonance with
If, my lord,
is in consonance with clause 2.2,
is 60.
no, is in consonance with clause 2.2 of appendix 1.
Page 104, that clause is there, ma'am. 104 of the National Highway.
Of the clause 2.2 of the appendix 1 of the guidelines issued by the Ministry of Road Transport and Highways dated 26/6/2020. Mr. C. Bulwer, the learned counsel, appearing on behalf of the National Highway Authority of India, submits that he would obtain instructions in that regard. List the matter again on, you get it on Thursday
Tuesday, no,
or Tuesday, next Tuesday? 13th?
Friday, possible.
Friday? Okay, Friday.
Right.
On 9/8/2024. Liberty is given to the parties to mention the matter for upgrading.
Copy to your convert.
And what is this IA business?
Getting,
That we treated as affidavit in opposition like that.
my lord,
IA for vacating?
Vacating.
Is,
IA condition. You were not appearing earlier. This order was passed in your absence.
In that.
And IA condemn. Also, the interim order passed earlier is extended till the next date. The interim order so passed on the ad interim order so passed on 5/1/2024 is extended after hearing both the parties and is converted to an order, to an interim order. The said interim order shall continue till the next date.
my lord.
The instant application have been filed for vacation, modification, and alteration of the order dated 5/1/2024. taking into account that in the writ petition, this court have, after hearing both the parties, extended the order to serve the instant application. The prayer made in the instant application for vacation or modification or alteration of the order dated 5/1/2024 is rejected. However, the instant application, as per the submission of Mr. J. Roy, the learned senior counsel appearing on behalf of the respondent numbers 5 and 6, shall be taken up, shall be kept on record for as an affidavit and affidavit and shall be kept shall be kept on record and be used as an affidavit on behalf of the respondent number 5 and 6.
My lord, may I get so copy of order I take out, but anyhow, I did
Dispose is rejected, but to be kept on record.
copy of
I
order.
stands disposed,
Yes,
yeah, it will be kept on record.
copy of order.
Order, don't you
I'll
get
get
it out
it,
there?
right.
You get it out there.
No, I'll take out.
Yeah. No, you don't need. You
No,
take
I
care
have
of it.
understood. I've understood.
And who is paying for the Ministry of Road Transport?
No, I don't appear.
No, because they are the main person.
Here, of course. No, we are following on that. That is why.
Understood. But who is appearing?
AK Google.
Huh?
One, Union of India is a party.
In India.
Who is appearing for the Union of India?
Mr.
That
AK
already
Google
liked it,
appear.
huh? Mr. R.K. Dev Chaudhary is also the learned Deputy Solicitor General of India is also directed to obtain instructions in as regards the above. Who represents the respondent number 1 is also directed to obtain instructions in respect to the above order. The registry shall show the name of Mr. R.K. Dev Chaudhary in the list. You inform him.
I mean, I'll give copy of.
Before proceeding further, I need to apprise your lordships, my lord, in respect of one, my lord, issue. In fact, what has happened, my lord, here,
You got the order? Yesterday's order? Both of you on the same side today. No. In fact, yesterday it was raining so much, but I made it a point to sign your order and leave at around 5 o'clock. But I reached home around 9:30 after leaving from here at 5 o'clock.
I was in my car for 4 hours. I reached 8:30. Hardly I take, my lord, 15 minutes to reach, my lord.
8:30.
Yes.
You're lucky.
Correct. I left court at 4, my lord. May please, lordship. My lord, here what I'm trying to say, my lord, I am challenging the action of a statutory authority, that is the deputy commissioner under a particular statute, state legislation, my lord. Now, my lord, the deputy commissioner, after approving the reclassification, my lord, under the act, unilaterally, on the basis of a letter issued by the NHIDCL, had cancelled the same. Now, that or cancellation is under challenge. Now, what has happened, my lord? Though the NHIDCL, my lord, incidentally come into the picture, my lord. Now, my lord, the bona fide, the question of bona fide is raised and a motive is attributed that to inflate, my lord, the compensation of the applicants, my lord, the bona fide is raised, that we have, my lord, filed the applications for reclassification. Because the argument has come that once, my lord, it is classified as industrial land, not agricultural land, the compensation, my lord, will, my lord, go up. Now, there are some documents, official communications, my lord, which we could not lay hand on, my lord, at the time of filing of the writ petition, which shows, according to them, my lord, the classification process, the survey, etc., it started in 23 September, according to them. Now, we have applications which was filed, my lord, in 22 September, 1 year back. But, my lord, since at that point of time, the official letter showed the portal was, my lord, non-functional. So therefore, it could not be, my lord, uploaded in the portal. And this, my lord, non-functional of the portal delayed the matter. There are documents of the deputy commissioner.
So these documents, my lord, are vital. I want to place on record to nullify, my lord, the allegation that there is some motive, my lord, in the applications of the reclassification. This would be important for us. So lordship will take up
They
this.
file an affidavit.
They have filed an affidavit. That, my lord, aspect has not been brought on record. But my lord, my learned friend, Mr. Gogoi, is arguing verbally, my lord, that our bona fide
Oh,
is
you are
under, my
arguing
lord.
verbally that?
Yes.
No, no. Why this has come now only? I have taken care of everything in the affidavit. In fact, my lord,
Have you raised the issue of the bona fides of the petitioner?
my lord, that has been referred to, my lord, because I have referred to the act. The act says once you get a permission to establish an industry, that has to be established within 3 years of getting permission. And this industry, which they purported industry, my lords, in one case, before obtaining of permission, they establish it in one case. And another case, my lord, the process was on. I want to indicate that if it was not motivated, then when highway was coming, you know about it, your industry is never going to see the day of light of the day. That says, my lord, that premises, my lord, it evidently makes it clear, my lord.
Mr. Gogoi, just one thing for my better
Right.
knowledge. When can a court take judicial notice that any person would have knowledge about a highway coming?
My lord. But there was a stakeholders meeting, and my lord, it was published, and my lord, the very act, but that they had, my lord, the same statute upon which they say they have a right, they apply. That same statute also lays down,
You are appearing for whom?
well, NHIDC, my lord. And
Then why do you have a provision under section 3C?
my lord. My lord, get objections, my lord, in case.
By 3C?
To hear them if any objection after publication of 3A, my lords, if anybody has some objections. But in
Objection
this
as
case, my lord,
regards what?
3D has come.
Objection as regards what?
Any interest on the land, my lords, which is going to be acquired.
As to whether he has any objection to the acquisition,
Yes, my lords.
which is parameteria with section 5 and 5A of the earlier act
My lords.
of the 1894. Whereby you can object that this is not in public interest, kindly don't take this land.
My lords.
Then what is the nature of a notification under section 3 capital A?
That is preliminary, my lords. That is only preliminary. It only.
What?
My lord, it only.
That intimating all people
it only-
concerned
Yes,
that
because
we
it-
are going to take this land.
Yes.
Can the court take judicial notice that they had intimation about this, that it is? I can't.
But in this case, my lord, 3D has come.
Understood, right? You see, there is no quarrel with the proposition that you have a right to acquire in terms of 3 ABCD. There's no. We are only concerned is what should have been the compensation. He says that this mile land have been all along applied for an industrial land which have been not taken into consideration by the rejecter here. On the other hand, while everything was going on at the behest of you, in collusion or at the pressure of you, the revenue authorities have made it agriculture. This is case.
My lord, in fact, the
Now,
communication.
can this court take into notice that in the look here, he knew from some time back that this land is going. If he has known earlier, it is good. Mr. Talukdar's client is very clever, very good. There was one judgment of the Supreme Court in the case of McDermott. It's a very important judgment. One has to read it. It's a case of tax. The judgment says that if a person can be made liable to pay a tax in this particular thing. It's a strict interpretation in the charging section. But if he knows how to circumvent it, you can't blame him for that. So here, Mr. Talukdar's client knew it we've got some information that look at this land may have or may be taken up for the purpose of road. He must have purchased the loan, he tried to make it industrial, whatever may be to get more compensation. But the question is, can they reject at your behest?
In fact, if my lord goes to the communication, which is purportedly issued by us, but it didn't say that you cancel only these persons. It was said the genuine grievances can be looked into. But you have to also see the attending for circumstances of all the claims you have received. It didn't say simply say that you demolish everything, you reject outright. No, it was said that DC can apply his mind. Genuine claims can be looked into. This is the standard.
So therefore, we are only here to see as to whether the DC applied its mind according to the provisions of the Act or were influenced by your letter.
My lords.
That is the
That
limited,
is my limited case, man.
That is
and
his-
for which the DC was asked to produce the record.
produce the record.
How did you form that opinion?
I cannot say whether it is original. This may not be original record.
Huh?
Contains some letters and also some.
Well, ensure that the records are produced, because on the last occasion you saw that the records were, it
And the
seemed that on
records,
this
they-
court had also directed to produce the records. Then if you are not producing the records,
These are the records they have sent up to us, madam.
okay, we ask the district commissioner to be present in court. Who is it?
Okay, but-
Which district?
I'll write once again.
Oh, no, this is the second time it has
Which
happened.
my
It can't-
records has to be with my.
Because you see, what is happening, he will come up with a 3D. After that, he will come up with a 3G. Again, the problem you understand that you have, your government has only given one special secretary to be appointed as an arbitrator. So if it is not done at the first instance, to get a thing done or making a reference to the arbitration in terms with dates, other states are not having that problem. And the state of Assam is having a big problem on this. You are having so many acquisition and arbitration acquisition matters, and this is what is happening. Isn't it, Mr. Wood?
I have been burdened with 13, 14 cases.
Huh?
I have been burdened with 15 applications.
No, you are burdened with 15, for which you would be
But no,
duly
indicate, but these are not-
remunerated
these are not
by
progressing,
the
madam. Madam,
government. It's a
These are not
different thing.
progressing. After cases, my lord, been given to the
But
arbitrator.
it is not that. You are only with 14, 15 or 13, 14. But look at the thing. One arbitrator has been asked. That day I got one matter where the arbitrator has clubbed all matters together as arbitration petition number 25 of 2022. Look at this. How is he doing? I don't understand. And this council comes out here and says that this court should pass an order asking him to arbitrator to dispose early. And arbitrator is not a party. And that too, arbitration in view of section 3G5, you are to also take note of the provision, the application of Arbitration and Conciliation Act. And section 29A is very clear. At the end of the day, that arbitrator is out. How do you take care of it? And it is only in Assam this is happening.
Here we had.
Earlier there were many.
Yeah.
There were 4 commissioner divisions.
Going on well, my lord. Well,
And that too, the special secretary was appointed at my behest. Otherwise it was not. You can ask Mr. C. Borua. They were not doing anything. They were saying that we are referring it to the so-and-so. Because NHAI or all these people, they have their basic idea is, why should we pay for the arbitrator? Let it be a government. And as such, initially rejected the special secretary also. But the special secretary said that he is not going to ask for anything. The government of Assam would be paying. Isn't it, Mr. Butchel? Isn't it? Now this is, and there is only one, and in that order, there is one matter where I passed an order requesting the government to appoint more special secretaries, because they have now issued a notification whereby only special secretaries can be arbitrators. So we need to finish up this matter as soon as possible. If it can be done and he is satisfied, he need not go to arbitration. But the records have not been
But,
produced.
This
The issue is very simple, Mr.
these-
Palika.
have all the papers, documents here, but not in origin. That is,
Okay, let us see whatever has been furnished. As to whether there, his order is based upon the directions issued by IA or is it independent of it? That's all. We come back at 2. Where's the order?
Order date, my lord, 8 January 24.
January.
Cancellation order.
In pursuance to the letter received by the so-and-so, the 19 April for recall. We set aside this.
My lords, will come to the.
Let them decide it
No, no, but
independently.
this- The said reclassification, my lord, that also suffers for non-application of mine, my lords. My lord, see, 70, page 76 of petition, my lords.
70,
6 of, Honorable Roy, my lords.
76 of the petition.
Minutes are there, but they are nothing, nothing, my lord. Just indicates some numbers, nothing.
Ah,
List of NOC, my lords, forwarded.
you see, they, at the end of the day, they would also be burdened. The simple is. Okay, we take it at 2 o'clock. I have another matter of this Kamakya matter which I'm taking up. And then there is 2 matters of Mr. AI which will take just 10 minutes. And then
Well, well.
a copy of it.
Yes, we have. Now, what if it lordship, whatever queries this honorable court and whatever materials is required for adjudication of the main issue.
Tell me, I see a PIL here, 12th of 2024. What is
Yes.
that matter?
That is the PIL. That is parallelly going on. So whatever documents we are submitting here, that is why in the first affidavit, the affidavit filed by the chief secretary in the PIL, I have to annex. And this is my submission from day one. In fact, I was about to start the case with the issue of maintainability. There, what is their main prayer? It cannot be a public interest litigation. It is a private interest litigation as it is a petition under 226 before this learned single judge. So what is his prayer? Lordship will kindly come to the page 40 of the prayer of the writ petition. So first prayer is page 40. A writ of certiorari should not be issued setting aside and quashing the impure notice of 15. That is a tender notice and work order. Was he a participant there? He was not a participant. He cannot challenge this because he is not personally aggrieved by this notice. The work has been allotted to L&T to a tender process. So he was not a participant and he is not interested for the work also. So this first prayer goes. Second prayer is also more or less same. Now coming to the third prayer, which they are not arguing for a single moment also. A writ of nature of mandamus shall not be issued to the respondent authorities, particularly the Archaeological Survey of India, to forthwith pass necessary directions to declare Kamakya Temple Complex as an ancient monument and national importance by exercising the power under Section 4 of the Ancient Monuments and Archaeological Sites and Remains Act
Okay,
1958.
Mr. Advocate General, others are okay. As
These
regards
two
E,
prayers,
no, prayer number E. Even a devotee can very well ask for that.
devotee now, he belongs to who are the priest there. No, he is not a devotee, he's a priest. He's a single priest. And there is an organization called Bordeuri Famas.
Hmm.
Toloi Famas, Lord. They were part of the negotiation and discussion with the government from day one. And in that case, the Honorable Supreme Court, they were a party. The Honorable Supreme Court's order, I would like to place, because in that proceedings also, we mentioned about this corridor project. And the Supreme Court, there is a direct direction to the state of Assam that we have to implement this project in true letter and spirit. I have that annexure of that order also. So he cannot coming singly raise all these issues. And if he wants to declare it under this Act of 1958 and rules of 1959, the main stakeholders there, suppose Lordship decides that it should come under Section 4 of the Act. In that case, the first casualty will be the priest there. And all the persons who are living in the adjacent of the temple. Nobody can. The deputy commissioner will become the main caretaker. That is not the idea of this holy shrine. And government also never wanted to do, and all the stakeholders except this particular gentleman lordship, nobody had that kind of thought process also. It will upset the whole scheme of things, whole system, whole tradition of Ma Kamakhya and shrine.
No, but whatever may be, the prayer which has been made in this amended petition of the PIL, which is before this court,
Yes.
I could see.
PIL, no, this is a writ petition.
Mine is the
PIL
individual
petition. There's a PIL, copy of the PIL petition here. Somebody must have given it here somewhere.
I don't, but
Somebody must have given some time back, I suppose. Anyways, the prayer which have been made as regards the white paper and all this thing, not to
absolutely,
proceed
Lordship.
with all
That
this
we are
thing.
disclosing whatever Lordship is asking us, same thing. In fact, whatever affidavit I am filing it, parallel affidavit I have to file there also. That is why in my first affidavit, I annexed the Chief Secretary's affidavit, which was filed
When
before
is the
court.
PIL fixed?
The matter
PIL.
next 2 weeks time. After 10 days, it was it will come any day, tomorrow or maybe within this week or next week.
So why this matter is not taken to the PIL?
I made that prayer also before the learned single judge in the earlier occasion.
My lord, I have
Yeah.
come as a body.
That is
I
why the
have come as a
maintainability
body.
point.
I haven't, my lord, my learned friend keeps on raising the issue of locus, let us settle, because the paragraphs 1 to 3 of my petition, they set out my locus. I am a body recognized in the 2015 Supreme Court judgment of Riju Prasad Sharma. I have extracted the paragraph.
Mr. Hazarika, this
Yes.
court is not questioning your locus,
Please, my
more
lord.
particularly in view of your prayer E. I'm
Yes.
not questioning it.
Yes.
Questioning your locus. But
Yes.
I'm asking as to why there should be two parallel proceedings in respect to the same subject matter. Why the division bench can't take up this writ petition?
My lord,
Taking into account that in respect to the same subject matter, another PIL is proceeding. You can
lord.
very well make your submissions there.
My lord,
Absolutely.
as an individual, because that is a PIL, these are devotees. Today,
No,
I have a
it's okay. The PI will continue on its
Yes,
own.
my
That
lord,
is
but
another thing.
I will lose a substantive right of appeal, which is conferred upon me.
Hmm?
I lose a right of appeal because today I'm before the single judge. Moment it gets tagged along with the PIL, and my lord, the additional prayers regarding the construction, etc., they are not part of the PIL. Wow. And my lord, today, my learned friend today, as per your
No, Mr. Hazarika, I have seen the prayers in the PIL. The prayers
Yes.
in the PIL are not same with what your prayers
Absolutely.
are. There's not, except asking for that archaeological thing. There's not, others
Please,
are
my
not there.
Please,
You
my
have asked for various other things that this particular notice of to proceed with the work and all these things, and more particularly the prayer number E
Please, my lord.
is not
And-
there in the PIL.
Absolutely.
But all said and done, the matter is now being taken up by the division bench in this issue. Then why, along with the PIL, this matter also cannot be dealt with by the division bench?
My learned friend makes the submission before the division bench, he makes it here because both courts have proceeded parallelly. 1. 2, my lords, I have today a higher and more substantive right being a body and entitled to practice in Kamakhya. So I can substantively maintain an individual petition in my own right. And if it gets clubbed with the PIL, I lose the right of appeal, my lord, if I go for a division bench. The right of appeal goes, my lords. How can I, my lords, lose that right of appeal? And today, my lord, my learned friends, they have today, pursuant to your lordship's order yesterday, because this matter is being progressed. So therefore, my lord, actually, more or less the same orders are being passed in that PIL is not getting anywhere.
Well, if I may, the affidavit which they filed yesterday is of some importance. Well, pursuant to your lordship's order. Because at the end of the day,
Can Lordship will kindly give me some time. I will make a prayer to the division bench. With
He-
application. Because same petitions, same prayers. In fact, I have the other day, I have made a verbal submission to the court. When the
No,
first,
Mr. Advocate General,
I
one
have
thing,
made all the
no, no,
evidence. We are
one,
not shying away from anything.
no,
But only thing is that regarding the
No,
maintainability
no,
point.
everything is okay, but the only thing is, one cannot also give up what Mr. Hazarika is also submitting to that effect. That he has a substantive right of an appeal if it is referred to the TF. But if the division bench has the power to call for this repetition, taking
That
it
is
back.
absolutely no quarrel on that. But when I have raised the issue of maintainability now, my next argument is when that prayer is there, I have made specific averments in my affidavits. Lordship may be pleased to take that matter, take that issue.
No, my question out here, which I passed on the last occasion yesterday, is as to whether, because you in your affidavit which have been filed out on 23rd of July 2024, you categorically say that you are going to duly take care of the water which is there and all these things will be duly taken. However, the question which have been raised out there that the MOU says otherwise, that it is the PWD department which is going to do it.
See,
Now, I have therefore put the question to the state today as to whether the PWD department has the expertise to do.
absolutely, Lordship.
That's
That is why my today's affidavit will clarify all the queries Lordship is raising.
Let us see then.
Lordship, it is on the way this time. No.
I've got it.
Yes. Let me place it, Lordship. Because the annexers are very important here.
Yes, yes.
The annexer of this affidavit.
You have a copy?
I have a copy.
Yeah, please place it.
Lordship will kindly come to page 443.
Yes.
That is on 24th, the reference, Lordship, that date is 24/4, no, it is 24/6 reference. That MOU dated PWD and IIT Guwahati.
25/4.
Yeah, yes, Lordship. The executive engineer wrote to the head of the department, Department of Civil Engineering, IIT Guwahati on 9th of July. With reference to the subject cited above, a meeting was held in your esteemed institute regarding survey of hydrological and geophysical investigation for the above mentioned project, wherein as specialized consultant, Person Overseas Private Limited had presented technical proposal for conducting the investigation. In this regard, I have the honor to submit herewith the proposal received from the contractor L&T Constructions for your valuable suggestion. Pausing here for a moment now, how this Person Overseas came into picture. In our MOU, what is written? That PWD, let me, because I have to think with the MOU. MOU, we said, Lordship will be pleased to take the MOU of 376, page 376.
Yes.
But I'm not giving up my argument on maintainability, Lordship. I'll describe everything. 376. Article 1, scope of work. The respective scope of work shall be undertaken by IIT Guwahati under this agreement shall be as follows. Scope of work. IIT Guwahati will provide technical advice based on geotechnical investigation, including hydrological and geophysical investigation carried out by PWD Building Department
and accordingly IIT Guwahati will submit a feasibility report to PWD building department. IIT Guwahati will examine the report and give the observations relating to the identified subsurface features as stated in the report. IIT Guwahati will provide vetting of geotechnical investigation foundation selection report submitted by PWD Buildings Department for new construction relating to the project. Vetting of structural design, drawing, work plan, and execution methodology will be done by IIT Guwahati, which will be provided by the PWD Building Department. Four. PWD Building Department will also ensure that the execution of the work plan and execution methodology are followed as per vetted by IIT Guwahati. Now, responsibility matrix, Annexure A. My learned friend read only clause the part 1, only one, Roman 1, yesterday. Now, Lordship will kindly come to 379. Responsibility matrix, which is a part of the MOU, providing all available information regarding existing projects site as per requirement of IIT Guwahati. PWD will provide the data. Geotechnical investigation of area by engaging third-party agency as per advice of IIT Guwahati.
So this is how person comes in.
Person will come not from this. Person came by the EPC mode 1. L1 was LNT. So
No. Geotechnical investigation of an area by engaging third-party agency as per advice. So
that area, it is not regarding the agency, the area.
So this is not for third party. So PWD has the power.
Third party will have to be done by some other party. Suppose this High Court building, for example, who constructed it? It is PWD. Does PWD do it themselves? No. They floated a tender and some agencies will come and conducted it. Here in this case, I think that Horlumuk contractor, he constructed, but it is done by PWD. So PWD or IIT Guwahati will not have that kind of manpower to collect the data. That is why I'll place everything now. It will clarify everything. So now third matrix. Specifying of area where geotechnical investigation will be carried out, IIT Guwahati. Technical advice, examination of geotechnical investigation report prepared by PWD building of the area. The observations relating to the identified subsurface features as stated to be in the report. Responsibility is IIT Guwahati. Vetting of geotechnical investigation foundation selection report submitted by PWD building for the new construction relating to the project. Authority responsible, IIT Guwahati. Vetting of structural designs, drawing, etc. Then the authority responsible is IIT Guwahati. So this is how the work will go. So when we wrote in the MOU that it will be done by IIT Public Works Department building, that does not mean that IIT PWD Guwahati the building will do it. They will do it through LNT because they are the contractors for the purpose of EPC. EPC means engineering, engineering, procurement, and construction. So this role of getting the investigation, approval, permission, etc., falls under the engineering this vertical. So the vertical of engineering is going on. So LNT roped in these persons. And therefore, what IIT said. Now next page. That will give more clarity. So project engineer, they wrote a letter on 9th July to executive engineer PWD. Please refer to the above letter relating to conducting of the hydrological and geophysical investigation for the project and a meeting held at IIT Guwahati team yesterday on 8/7/2024 on the same subject. We are submitting to you the technical proposal for conducting the said investigation work as submitted by the specialist consultant. Request you to review the same and provide us with your inputs to proceed further on the same. So the proposal was received by PWD from LNT. That proposal at page 445. Proposal for technical consultancy service hydrological and geophysical investigation for Ma Kamakya Temple Project Guwahati, prepared by L&T, prepared for L&T and prepared by Persons Overseas Private Limited, Delhi. Proposal number of April 2024. These are not new things now. Because of these petitions, all these things sprung up. No. This petition was filed in May. All these things were already there. Now, next page, 446. One senior geophysicist for internal audit report offsite who may take a short site visit if required. Schedule. Mobilization within 10 working days on issue of work order and release of advance. Hydrological survey study 10 days. Geophysical investigation for aquifer water channel 20 days. Geophysical investigation at ponds 15 days. Geophysical investigation for construction purpose 30 days. Report will be submitted within 10 days of fieldwork completion. The deliverables, payment structure, etc. These are there. Now coming to page 448. Proposed survey methodology, hydrological study, introduction. I'll read out the relevant portions, Lords. Groundwater is a vital and dynamic resource that necessitates careful scientific study and thoughtful planning. To ensure sustainable management, long-term strategies are essential for overseeing the groundwater resources in the region. There is a pressing need to establish the in-depth comprehension of the hydrogeological conditions and groundwater systems. These understandings will facilitate the resolution of issues relating to construction activities in the project area, particularly to prevent disruption of water channels that are crucial for the sacred temple ponds. Methodology. In general, the knowledge of groundwater resources obtained by the monitoring of existing wells in the area, detail regarding continuity of aquifers, depth of the water table, water quality are made by interpolating results between adjacent wells, ponds. The survey aims to provide hydrogeological information regarding the occurrence and depth of groundwater throughout the area. The result of the survey will enable the groundwater patterns of the area to be understood and managed in such a way that the existing ponds are not affected. Objective of the investigation: to map the aquifer of the area using hydrogeological and geophysical resistivity techniques. Component of investigation. The activity to be undertaken for the projects are summarized below. Geological study surrounding the area, geomorphological study of area, analysis of rainfall data, drainage pattern area of the area, preparation of digital elevation model of the area through SRT data, groundwater level monitoring and aquifer system pattern determination, characterization of groundwater flow direction in the area, integration of hydrological and hydrogeophysical data for identification of aquifer system, final interpretation and integration of all new data into the final mapping. Now next page. Proposed survey methodology, geophysical investigation. Electrical resistivity imaging tomography. 2D resistivity imaging uses an array of electrodes, typically 64 connected by multi-core cables, to be provided by linear depth profile or pseudo suction of the variation in resistivity both along the survey line and the depth with depth. Switching of the current and potential electrodes pair is done automatically using a laptop computer and relay box. The computer initially keeps the spacing between the electrodes fixed and moves the pairs along with the line until the last electrode is reached. The spacing is then increased and the process repeated in order to provide the increased depth of investigation. So these are scientific ways how the principles are laid down. Second paragraph from below, the maximum depth of investigation is determined by the spacing. Now coming next page.
Mr. I am a graduate in history and did my law. I am not so much into all these things. But I think for my understanding out here is the PWD building department is not going to do. That is a part of the contract which is given to the L&T.
L&T and
L&T will provide the technical know-how as regards to person, and person would be doing those surveys and thereupon submitting to the IITG, which IITG will formulate. That's it.
and without their approval, without clearance from not only IIT but other agencies also.
in
Not
other
a
wo-
single brick will be laid.
In other words, a company, as I could see from here at paragraph page 453, this is a company which is of the first, has the privilege of being the first company in India to introduce velocity gradient system and all these things.
Yes, they have done
This
in army
particular
project.
company will provide the scientific inputs as regards hydrogeological and so and so. It is
Lots.
not being done by the PWD building. PWD will, it will then, through the PWD building, it will be submitted to the IITG, which will.
Yes. Absolutely correct. Dot on.
This is the simple thing.
Yes, now page 452 for a moment. The following, for the present project, the following are proposed. ERI and SP profiles at 10 locations identified based on hydrological investigation. ERI and SP profiles all around holy ponds adjacent to 10 temples in the study area. ERI and SP profiles all around 2 points near playground near the MLP, the multi-level parking. All this, then the page 53, the procedures, etc. And the water levels, all these are given. Now, on the basis of this, what IIT responded, that is at page 458. It is an ongoing process. They had some queries now regarding person and what are the areas they are going to do. That is on 18 July 2024, written by the IIT Guwahati to executive engineer. The proposal submitted by persons overseas has been reviewed and the following are the observations on the proposal. The study area catchment that comes under survey shall be demarcated properly. Details of the hydrological study, including its component and derivatives, shall be provided. Whether the mapping of existing open water bodies will be part of the hydrological survey shall be stated. Reports should be provided in stages after the hydrological study, and interim report can be given and discussions can be done for outlining further ERI SP. Specific limitations, challenges of ERI SP in identifying aquifers and flow of path of the sloping vegetated hill study shall be stated, etc. Now coming to 9. The component of the investigation should be elaborated, including geological survey, how it will be done, what will be studied, and what are the deliverables. Drainage pattern, how the drainage pattern will be identified for the hill slope with vegetation and what deliverable will be. DEM through SRTM, the feasibility of using 30M resolution data for a small hill shall be assessed, and whether this course resolution would suffice for drainage studies shall be determined. Proposal for drone survey, whether a drone survey of the high resolution DEM development can be conducted and the challenges posed for thick vegetation shall be stated. That way, they have also come to 11. Application stated in page 52, general details relevant only for the project shall be stated. ERT methodology adopted for urban and vegetated hill regions shall be specified. What ERT will identify, like only water saturation for aquifer interpretation, or shall be detailed rather than providing general description of ERT. 12. Is it possible to identify 10 locations before the hydrological survey? The number can be more, less or more. It is better to state that this based on the initial hydrological survey. This means there should be different stages of report submission as detailed above. First stage deliverable will be the hydrological survey and the strategy for ERI and SP survey. Details of the total holy ponds and temples in the hill shall be verified if a reconnaissance survey has already been completed and details of the hills are available. This shall be provided for review. Need for seismic reflection, then finally, regarding the process also at 16, they have suggested the possibility of using EVRI instead of ERI should be explored. Electrical vector resistivity imaging, EVRI, offers higher resolution compared to traditional ERI. EVRI provides more detailed and accurate subsurface imaging along with the enhanced 3D capabilities. Earlier, their proposal was for 2D. With enhanced 3D capabilities for comprehensive subsurface visualization, this improves the detection of soil and rock variations and anomalies in aquifers. Finally, the objective is to identify the source of the eternal spring present inside the temple complex and its possible pathway. This will help assess whether any construction downstream of the temple complex will not hinder the free flow of the spring. The methodology of ERI and SP should clearly align with this objective, and this shall be the specifically stated. And one more line, they wanted what work this organization has done. That was also there, the history, their credential. That was also one of the query of the IIT Guwahati. 6, paragraph, previous page, Lordship. Details of notable case histories where Person Overseas Private Limited was involved in groundwater flow and spring investigation of hilly regions shall be provided. Now, in response to this, Lordship, the reply was submitted on 26th of July. On 26th July, the letter from the executive engineer went to the IIT Guwahati. With reference to the subject cited above, I have the honor to submit here with the point-wise reply received from the contractor L&T Construction, file reference 3 regarding hydrological and geophysical investigation at Ma Kamakya Temple Access Corridor. And the report is at page 461. Point-wise reply has been given.
This report is submitted by L&T,
L&T, because
not Person.
from persons they collected and forwarded it to
No, this is letter is signed by the L&T,
L&T, but Person has given them.
but
Ulti-
earlier it was given by
Because we
Person.
wrote to L&T.
But earlier everything is being written by Person only or L&T.
Annexer.
Because the earlier proposal was given by the Person. This is not by L&T.
Lordship will kindly come to Annexer B, page 466. So they started with 2D.
466.
Yes,
Yeah, Person is given.
persons. And ultimately what the IIT Guwahati said 2 days ago, after receipt of this report on, and Lordship will also see these photographs, how the data are collected. 469. Clearing of grass, bush by laying resistivity profiles in heavy vegetated areas. How the electrodes are fitted. 469 and 470. And from on the roads also 471. Here they have decided to work on for the road at night so that there is no traffic problem. Now coming to 473. On 3rd August 2024. And in fact, regarding the total number of sites, which person suggested 10, then it was decided that it will be jointly page 463 for a moment, Lordship will kindly come. (463) serial number 12.
473.
No, 463. Because from IIT Guwahati, they said, is it possible to identify 10 locations before the hydrological survey? The number can be less or more. It is better to state this based on the initial hydrogeological survey. This means there should be a different stage of report submission as stated above. The first stage deliverable will be hydrological survey and the strategy of the ERI and SP survey. Reply, location will be decided jointly by IIT Guwahati during hydrological study site visit. So they will also come to the site. It is not that they will be only sitting in Amingaon and do the work.
Now kindly come to page 473.
473. Yes, this is the response. We have reviewed the clarification provided by L&T. The proposed procedure may be adopted to study the eternal springs of Ma Kamakya Hills. That is one part. However, data should be collected at a finer resolution to ensure the identification of
Now,
smaller.
this is the most important thing.
Yes,
The proposal procedure may be adopted to study the eternal springs of Ma Kamakya Hills.
Then
We are
now,
only
this is 2 days ago. There will be further.
understood.
interaction.
No, understood. Everything is understood. This is the only question which have been raised by the petitioners. This eternal springs which IITG is duly taking note of. Because you see, if you see the report which have been submitted by person earlier, I don't know much on these technicalities, but whatever it is referred to is as regards the ponds. Kindly see everywhere, they are only referring to the ponds. Page
Ponds and streams,
448.
Two
the-
parts, 2 ponds and other streams.
Understood. You see, they are different thing. You see, kindly page 448. The result of the survey will enable the groundwater patterns of the area to be understood and managed in such a way that the existing ponds are not affected.
Not affected.
So here, there is a difference between the ponds and the eternal springs, which is the main, and this, the IITG has duly reflected.
And on top of that, previous paragraph, introduction, last line. This understanding will facilitate the resolution of issues relating to construction activities in the project area, particularly to prevent disruption of the water channels that are crucial to the sacred temple ponds.
Again, coming to the pond.
The pond is, that is pond, but
One
one is
is-
that one goes to the main sanctum.
No, that is understood. But however, the IITG has duly pointed out at
Yes.
page 473
Yes,
as regards this eternal springs.
yes,
From the eternal springs, it comes to the ponds, if I'm not wrong.
yes. So ultimately, Lordship, if Lordship is pleased to look at the NIT now for a moment.
NIT.
Yes. The writ petition, Lordship will kindly take.
Page.
Just 1 second. Page 200.
Yes.
Here, the bullet mark development of site that is on top, middle, liaising with statutory agencies like etc. All these agencies, all the permissions they have to take. And last one, obtaining mandatory approvals, pre and post construction from all local bodies, state and central authorities, municipal corporations, EAI, clearance, fire clearance, forest clearance, etc. for the complete work in the scope of this work. Approval as per etc. So before getting all the approvals from all other agencies, including IIT Guwahati, no work will be started. That is a specific requirement in our affidavit also. So these are at the stage of engineering. And finally, page, Lordship will kindly see page 202.
Now, in this, where is the reference to this hydrological and geological survey to be done through the LNT?
Here,
Or
all
are you having a separate contract with
No, no.
person? You are
It's a-
doing it through
No,
Pari.
because here, not only this hydrological, including fire, including forest clearance,
No,
etc.
but that is a different thing. I'm not on that. But whether the contract with LNT envisages that the hydrological as well as the geophysical study would also be
That is
made
a-
by the
That is a
hydrology.
part because all these meetings, when it was held in Delhi before approval of the, or in all meetings, the Ministry of Culture comes. Then this archaeological survey, etc., they are part of those. So all these agencies are part of it.
No, but
all
it
the
is,
line
but
departments.
it is not a part of the.
No, now suppose
contract.
it is not there. For example, let us assume hydrological, our thing was that geology, all technical survey.
No, my only specific question is as to whether you are going to rope in person separately or
No.
is it through the LNT?
It is through LNT.
So,
That amount also they have to pay.
Understood. So if that be so, it would be
Yes,
a part of
Lordship
the
will kindly
scope
come
of the-
page 199. The second paragraph. The contractor shall obtain all pre and all post-construction clearances. Approvals from the statutory authorities.
No, understood. That is another thing from saying that whether who is going to do.
No, it will be done by them.
Understood. But are
And
you
the payment will
roping
also
in
be done by
persons
them.
separately or through this LNT? That is my.
Through LNT, because EPC contractor L1 is LNT.
It's okay, but the scope of the work includes, if you see page 199,
199.
it doesn't say anything about that.
Now
about
here, this line is very clear, general line.
Yes.
The contractor shall obtain all pre and all post-construction clearance. Now, what is pre-construction clearance?
From whom?
Approvals from statutory authorities.
Who are the statutory authorities?
Now, here, statutory authorities in one another, in the agreement, another point, there is word ETC was there, etc. was there. Here it is statutory authorities.
No, because you are saying about the mandatory approvals from persons like the central authority, municipal bodies, EIA,
The scope
clearance,
of work
fire,
includes-
forest, and etc. But
And
does
then,
it
Lordship,
say
may I read, let me read. We cannot interpret this contract in the line of how we interpret a statute or a constitution. Here, certain things.
No, why
are
I'm
in-
saying is, if you see the today's contract document, which you have enclosed as affidavit, it categorically says something else. Why you are saying that this is why they are saying, this person is saying out here about how much charges they are going to make, when the payment milestones.
Before,
That is why
above
please-
above 5 lakhs and below 5
No,
lakhs.
no, 445 and
Yeah.
446, they say this. So therefore, my question is as to whether you are roping in persons
No,
independently
persons we
or
have not. We have not. PWD have not. It is LNT. Now, for this moment, Lordship will kindly see page 199, the second line.
Hmm.
The scope of work includes required services, electrical installation, etc. So all these are included in the scope of work. So when we say the pre-construction clearances, why this clearance is required? To start the construction work, and therefore one more important thing, Lordship. Page 202, for a moment, Lordship. Note, the payment shall be made on the area basis with respect of each building. Suppose certain buildings are not approved by IIT Guwahati, so he will not get the money. So whatever permission is granted by the competent authority or agency, then only the payment will be made.
no, Mr. Advocate General, I think you should not make that submission at all.
I have to make it, Lordship.
Meaning thereby, if they make a without permission, he may not get the payment.
No,
But
no, he
but
cannot construct because it is not that
say
PWD
that
engineer
he
should be sitting
cannot
idle.
he cannot construct is a better wording than to say that he will not get payment.
no.
If
What
he
I'm saying-
constructs and
He cannot construct and he will not get also, because when he had submitted the tender under this EPC mode, his general conception is taken that a particular work will be done. Suppose that work cannot be done, then he will not be able to claim it. There's a different module, different scheme for having EPC work. We cannot give the proper district area regarding the work. Lordship will kindly come to page 206 now. Description of the activities now.
Yes.
Description of the activities of LNT. Planning, survey, investigation, including soil investigation, and other related works and services, obtaining all statutory local body approvals pre and post construction through the statutory bodies. The agency also take permission from the fire department, environment, pollution control, other necessary approvals from local bodies, etc. This is the word I said, etc. etc.
ETC means?
etc.
No, I know. Means
Now IIT Guwahati here.
No, it's okay. IIT Guwahati is okay. For that you have AI, it's okay. IIT
The
Guwahati.
local bodies, Lordship was putting that query that statutory body. IIT Guwahati may not be statutory body from this perspective. But they also are under a statute. IIT Guwahati is also under a statute. Required to start construction
Has
as per clean theory given above.
has L&T filed any affidavit?
L&T is a party, but one very important affidavit is on the way. My friend was just informing me. ASI's affidavit.
Yes, L&T, what do you say about this person thing? Is it included in your scope of work? No, this is not.
It's from the forest department.
Environment is
Right.
forest.
And clearance and Lordship, may I continue, Lordship, here? And clearance and compliances, traffic impact assessment, designs of merging, demerging of traffic, comma, etc. is again here.
Scope of the building. You have entered into an agreement with L&T?
Yes,
Where is that?
we have not filed it. No contract of PWD can be executed without a contract agreement.
No, therefore.
But their case is that they want this temple should be brought under the 1958 Act. That is number one. They want to continue praying there. That is number two. These are the prayers. They have not challenged the contract.
But you are not.
No, they are not. They are not challenging the issuance of contract to L&T. There is no such issue here.
Of course, we are.
No, they don't have. They don't have a problem in you giving to L&T or whoever ABCD. They have no problem with it,
Lordship is
isn't
now
it,
asking the
Mr.?
contract agreement.
Yes,
That's why
yes.
I have to say.
You have no problem with.
I'm not.
Your only thing is, if you are doing it, you do it properly by holding this seismic hydrological or geophysical study properly and then do it. That is his.
Preserve the eternal springs everywhere. in
Now,
all
from here, it reveals that it is the PWD is doing it through this Paragon or whatever maybe.
No,
Person.
it is
They
made
are
to
doing-
L&T, Malaks. L&T is engaged persons.
Ah.
So the private
L&T through L&T, but L&T is engaging person.
absolutely. So today,
L&T
the
is
private
engaging person,
contractor,
and there these things are being taken. These are the proposals which are being submitted. Now, this affidavit you have looked into, Mr. Hazarika?
yes, Malaks, if I may address your lordship on that. If your lordship sees paragraph 3, as your paragraph 3, they have said L&T, which is an interested party, getting 400 crores, is being asked to conduct the geophysical and hydrological survey, which will decide the future of Kamakhya. The future of Ma Kamakhya today rests on Mrs. Parsons. Now, what is the experience of Mrs. Parsons? Your lordship may turn to page 462 of the affidavit. They have 462.
Yes.
Your lordship sees at the top page.
I have not completed Lordship.
Point number 6, details of notable case histories. Your lordship sees that. Notable case histories where Parson Overseas Private Limited is involved in groundwater flow and spring investigation of hilly regions shall be provided. L&T reply. This is a query clarification sought by IIT and they are responding to that.
Yes.
Project. So project details, if your lordship, there are only two experiences of Parson details. Groundwater, rainwater harvesting in Hyderabad and some other army project. Your lordship may see that. That is all. Mrs. Parson has undertaken many studies which involve the combined application of hydrogeological study and geophysical investigation. One major project that was done for rainwater harvesting for ISB campus in International School of Business. Another project of somewhat similar nature was undertaken for an army complex which has a lot of undulating terrain and heavy vegetation for groundwater mapping, drainage patterns and groundwater recharging. So it is rainwater harvesting. That is the experience they have. When IIT sought their experience. The private contractor gets it as a fundamental conflict of interest. It's a related party transaction. Where is the question of any credibility? The future today of Ma Kamakya entirely vests in them. And even the MOU with IIT is worded in a way that it is only relating to the structure, which my learned friend showed to your lordship, page 376. Page 376, the MOU with IIT does not mention preservation of eternal springs, does not mention mapping of aquifers. It relates to that NIT thing of how the structural part will be there. Now, whenever there is a structural part, there is always a geohydrological part. And I didn't show one page to your lordship yesterday where they have taken permission from Pollution Control Board to extract 430,000 liters of groundwater. So none of the figures, and we spoke, that's a page 305, your lordship may see. I forgot it, but it's very important. And there is no mention of eternal springs, there is no mention of the seismic aspects, which the expert, Dr. Sarada Sharma has pointed out, that it is a seismic hypocenter. Is person overseas, which does only groundwater, rainwater harvest, capable of undertaking a seismic study? I mean, your lordship, I showed your lordship the MOU between ASI and GSI yesterday. What is the extent and scope of study? Look at the army of geologists they have. Look at the wealth of experience they have. Today, we have an agency which is engaged by the contractor who is getting 400 crores to do this as a post-facto rationalization. And there is nobody is taking any guarantee. Neither IIT is taking any guarantee, neither is LNT giving any guarantee. Nobody is taking any responsibility. Responsibility is only of Mr. Raj Chakrabarti, the special commissioner, who has said that there will not be no disturbance will be caused to the eternal spring. And then when they are dry up, he will say that it is not willful disobedience because we gave it out to. So that's the end of the matter. Nobody has taken responsibility. And the moot point is that the preservation of eternal spring, mapping of aquifers is not in the MOU with IIT. Therefore, IIT is giving study on other aspects. And peripherally, therefore, they have mentioned at page 473, which your lordship I'm grateful to your lordship has pointed out the eternal springs have been protected. And if your lordship sees page 473, this is very important. Your lordship may just turn to page 473 of the affidavit. The affidavit filed by my learned friend, IIT clearance. At the end, they say, since most construction activities will occur at a lower elevation than the temple, the study must ensure that recharge zones are protected and the downstream flow from the temple remains unobstructed. Today, it is not Ma Kamakya. It is the entire Dasam Mahavidya complex. All those temples, whether it is Ma Bhairavi, whether it is Ma Dhumavati, whether it is Ma Chinnamasta, whether it is Kameshwar at the other end, all of them are at a lower level. They are obviously interconnected. So you have not even taken that into consideration. You're only taking one temple into consideration, and that you don't even know where it is gone. It's just a casual observation. Is that how it is going to be done?
But Mr. Hazarika,
yes,
it is not that the IITG is not taking note about all these things. They have been placed certain materials, which on the basis of which they have made certain pointed queries, to which LNT had replied, and thereupon also the IITG has also given this letter.
Please,
now, as regards whether Paragon or this person has the expertise or not, isn't it a question that the LNT does not have the expertise to do this? That is why my specific question to the Advocate General was whether this seismic study and all was within the scope of the work, or is Paragon separately engaged? Because as you see at paragraph page 199 and 200, there is no specific mention about this study, whereas all other things have been mentioned. So is it outside the scope of the work about this, and thereby they are engaging person?
I'm grateful, Mela, because this is what I stated yesterday, that this is a post-facto rationalization. When they initially started up with the project, I showed your lordship at page 112, it was on the basis there was a sculpture there. So the 14 crores was spent on at page 112. Your lordship will see that the sculptures will be protected, not the eternal space. Your lordship may turn to page 112. This is for the architectural bid, consultancy. Then after that, the LNT submitted the bid. Your lordship at page 112. Yeah. The background and name of the project.
The person seems to have been roped up.
Absolutely.
Only at on 9th of July 2024. I'm
grateful. It's a post-facto rationalization. After these petitions came in, they realized that they have proceeded on the basis eternal springs or disregarding them entirely. Now it's a post-facto rationalization doing this. And the MOU with IIT is very clear because it speaks of the structural aspects. It does not speak of the opinion of Dr. Sarada Sharma, very simply put, that you have to trace the aquifers because water flows through rocks. The water flows to granite and igneous rocks. So you have to ensure that the balance is not upset or they are not dislocated. And the seismic aspects, because the seismological hypocenter, etc., someone who has only groundwater recharging and rainwater harvesting experience, how can we expect someone to do that? And that to be an interested party is getting 400 crores. There's a fundamental conflict of interest.
Mr. Hazarika, why are you into this 400 crores? It may go up.
Yes, it may go up. I'm sorry.
May go up. If there is a further delay into this project, it may go up. But don't restrict yourself to only 400 for the time.
Well, as lawyers, we are is the escalation clauses which fetch the money.
No, it may go up. Yeah. No, I'm only on the question, Mr. Borpujari. You are appearing for the L&T. Is it within the scope of your work as per this NIT of doing this survey or putting all these things? Because I don't see it from the scope of the work that this is all. It's okay. The government is doing a right thing by going into all these things. It's a different aspect to the matter. But whether it is within the scope of your work.
Lordship, let there be pleadings on that. Whatever pleadings will give reply. All these are offshoots. They are diverting.
No, I'm not on those other aspects.
Court also,
No.
sir, queries are coming very nice. We'll welcome all these queries. Let there be pleadings first. First, Lordship will decide whether.
No, because no.
We'll give all replies. This is not a PIL.
So, Mr. Advocate General, I am not on. No, I am not on that. I made it a specific thing on the last occasion yesterday as to whether the PWD has the expertise. You have come up with a thing that you see PWD is not doing on its own.
PWD
obviously,
cannot
absolutely right. Everything where it is always done through the PWD. I
Now,
understand.
suppose pollution control. There can be other agencies also who can assess pollution. Whether in that we have to get it from Pollution Control Board. So there are a lot of agencies.
Understood. So there is no
And
quarrel.
these gentlemen, the other side, they do not have any now. They are making a lot of loose talks. That all of a sudden, as a second thought or as an afterthought, we brought in person. Lordship will see when this IIT's MOU, when it was started, when it was conceptualized, it was on 6th of April, when we first wrote to IIT. And what is person doing? Suppose they are very much, now they are the self-style expert, that's Sarada Sharma. Will he go and collect these data? Suppose we give it to him, they'll be very happy. It is not possible for them to collect the data. The data will have to be collected through an agency and persons is precisely doing that. Whatever data the IIT will indicate, that data will be collected and it will be given.
No,
to
Mr.
IIT
Advocate
Guwahati for
General,
possession.
no, kindly listen. You issued a notice inviting tender on 28/11/2023.
Right.
At that point of time, your MOU with the IITG was never an issue. All tenders were submitted.
No, Lordship, let there be complete pleadings.
No, it's not a question of
Let there be
pleading.
complete pleadings, whether they want.
It's not a question of pleadings,
Pleadings.
Mr. This court had specifically put to you a question as to whether the PWD.
No, Lordship, how this private person, writ petitioner is aggrieved by that? That will have to be, because this is a writ petition where he is seeking mandamus and certiorari. This is not a PIL. How he is aggrieved?
He's a devotee.
He's a
I'm a
devotee.
body.
He's a priest.
I'm pleased.
He's a priest.
He's a priest.
Priest. And there will not be a single construction within the periphery of the whole temple. No priest is affected. Our affidavit clearly says.
No, I don't understand this this submission because of the fact. Forget about that. He's a priest. He is also a devotee.
No, he is a devotee. Fine.
If he is
I
a
am also
devotee, if
I
he is
am
a
also
devotee, if
Now,
anything happens
in
to
that
the
case,
internal
in that
screens,
case, Lordship, how the project is being progressed, that has been looked into by the division bench.
let it be. The division bench has not called this matter from the clutches of this single
No,
bench.
I'm not. Because
So
I'm
let the
only,
division
I am
bench
only,
pass an order to them.
I do not have any, if they have precisely challenging the tender process, This is the right forum.
They're not challenging the tender
They
process.
are challenging the tender.
They're not- You see, the
The
difference
work
between,
order, work order. they
difference
challenge.
between a PIL and a writ petition is,
Now, then Lordship will answer this question that regarding the maintainability.
Yes.
Lordship will hear this tomorrow or maybe day after tomorrow. Let them also argue and I'll also make my submission. After that, Lordship, this case can go further. Whether it is maintainable under the present facts and circumstances.
no, Mr. Advocate General,
Otherwise,
it-
on the
don't
the
you think
contract
that
agreement,
when,
I'll place.
no, Mr. Advocate General,
I will not sigh out anything from the PWD, whether the contract agreement has a
no,
specific.
Mr. Advocate General, I make it very clear to you. The matter is when I'm holding the roster out here, the matter is with me. So under such circumstances, the manner in which I will proceed with the matter is absolutely within my jurisdiction.
Absolutely. That is
You
why
may very well ask the Chief Justice to get a transfer of the
No,
matter
I-
to any other court.
what I am
But,
saying,
but
when I have
no,
raised the.
no, Mr.
no,
Advocate General, I make it very clear. My only anxiety, I'm not bothered with other things as regards the other prayers. Only anxiety in view of your affidavit filed on 23rd of September, July 2024, wherein it says that you are interested as regards the maintaining of the natural springs. It is too. It is also seen from at page 473 of that affidavit, which the IIT has also stated that these eternal springs requires to be protected.
Absolutely.
So under such circumstances, who is going to do it? Are you roping because I asked the question because as per your MOU, it is the PWD building who is going to do it. Today you say, yes, PWD building always authorizes other persons. Now, L&T, is L&T doing on its own or is it doing through the person thing? Now, if it is doing through the person, it's a different aspect of the matter, but from the notice, detailed notice inviting tender or the scope of the work, it is not seen that this portion is a part of the contract.
Let that order be passed by someone. We'll come with affidavit to that effect. Let that order be let observations be given in the judicial order. We'll respond to it.
That is why I asked the L&T.
But
You see, what you have done, it is not spelled out here. Therefore, I asked the L&T as to whether L&T is going to take up this aspect of the matter. Let L&T reply to that. Where the L&T is
Then
being
L&T
duly
will reply.
represented.
ultimately it is the PWD will have to get into the scheme of things.
And PWD, whether it is doing or not, because PWD is going to do it as per your MOU through some external agency. There's no quarrel with that. You can do it. There's absolutely you do it. You appoint somebody, whoever it is, or you employ the L&T services, very well you do it. Mr. Advocate General, I make it clear. Whatever the IIT-G has stated at page 473, there is no forms that anything is required to be done by this court. No. But it is to be done in the proper manner and as to whether it has been done to the proper
it has to be
agency.
done under the aegis
Yes.
of IIT Guwahati.
Yes,
They will
very
monitor.
well.
They are indicating what this person is doing. Person is given the responsibility to collect the data. It is as simple as that. Who will process the data? Who will give the opinion on the data?
As engaged person, that is why my question is,
And engaged by
let L&T say that we are engaging person on the basis of this contract. Let that be the only thing which I am asking.
that if it will definitely be filed.
Only that aspect, nothing more than that. That
No, it
person
is-
being engaged because that is a part of the contract. That's all.
Because it is already stated in page 441, your lordship.
Yes,
Because you see, a person is a small entity. The entity which is the bigger entity is L&T. If it is rope-free, L&T,
L&T will do lot of other things for other agencies also. It is not that only person.
whatever may be, L&T, how they do it's a different thing. But why I'm saying is because from the scope of the work, it is not seen that this very aspect was there. Even in the notice inviting tender, the idea that you are going to enter into an MOU with the IIT-G was not a part of it. Can you appreciate that? Why I am saying so? I have no problem with L&T saying that we are going to do that. And it is our subcontractor who is doing it through the
Now,
person.
the
It's
lead
okay.
petitioner is having problem with IIT also.
No,
They
no, no.
want Sharada Sharma.
Problems, no?
That is
They
why
may,
all these
Mr.
reports of Sharada
Mr.
Sharma
Advocate
have
General,
to
that
appear.
the lead petitioner has the right to say many things, but it is for this court to accept.
No, definitely, Lordship's query will be replied through records, not on the submission of the council.
The only thing is, this court wants to know whether this seismic is a part of the scope of the work with them. And whether they are going to, on the basis of that contract, that's all. I want only
Let
that.
that be in the form of an order, Lordship
Yes.
will give it. And my submission once more, Lordship, the issue of maintainability may be heard at the beginning itself. This is my third and fourth prayer in all the hearings.
That day I passed the division bench, in the division bench, I've taken up a matter and I passed an order. An issue of maintainability was raised on the ground that their public interest litigation was not in terms itself or in terms with the Guwahati High Court rules. The division, sitting on the division bench, I've made a categorical order that maybe that is not there, but that does not take away this court's power under Article 226. So don't worry about that.
No, no,
I'm not-
it may go against us. I am not on the.
I'm
the
not
Lordship
on
may
that.
held it in
My
favor
only
of me,
anxiety-
against of me.
No,
That
Mr.
is not the issue.
Yeah.
But the question, I want an answer because the law is well settled that when an issue of maintainability is raised, it has to be decided at the very beginning, at the threshold.
This court, by an order dated 5/8/2024, fixed the matter today, taking into account the submission made that the learned Advocate General, Assam, would be addressing this court. Accordingly, the matter was taken up for hearing as to whether the PWD building department of the government of Assam has the resources to carry out the geotechnical investigation, including the hydrogeological and geophysical investigation, as stated in the MOU dated 25/6/2024. An affidavit in opposition, an affidavit has been filed by one Raj Chakraborty, who is the Special Commissioner and Special Secretary to the Government of Assam Public Works Building and National Highway Department. In the said affidavit, there are various documents enclosed. Before taking into account those documents, this court finds it relevant to refer to the notice inviting tender, which is Annexure O to the writ petition. The said notice inviting tender was issued on 28/11/2023, pertaining to the work of Ma Kamakya Temple Access Corridor at Guwahati. In the said notice inviting tender, the brief particulars of the work as well as the scope of the work have been duly mentioned. In the technical bid civil work section. A perusal of the scope of the work though mention various aspects, but it is not clear as to whether the geotechnical investigation, including hydrogeological and geophysical investigation, is a part of the scope of the work. In the said backdrop, let this court now take note of the affidavit so filed today by the respondent number 6. From a perusal of the documents enclosed to the affidavit, it is seen that the executive engineer PWD had written a letter to the head of the Department of Civil Engineering, Indian Institute of Technology, Guwahati, wherein it was mentioned that a meeting was held at IITG regarding survey of hydrogeological and geophysical investigation. Wherein a specialized consultant, Person Overseas Private Limited, has presented technical proposal for conducting the said investigation. The proposal, which was received through the respondent number 10, that is the L&T Construction, was submitted to the head of the department, IITG, Department of Civil Engineering. In the said proposal, which was submitted and enclosed and made a part of the Annexure Roman 1 to the affidavit dated 6/8/2024, there's a letter issued by the project manager to the executive engineer PWD building project manager of the respondent number 10, thereby submitting the technical proposal for conducting the hydrological and geophysical investigation as submitted by the specialized consultant. And that the PWD work building department was requested to review the same and provide the respondent number 10 with the inputs to proceed further in the same. The proposal was submitted by a company, namely Parson, P-A-R-S-A-N, Overseas Private Limited. Is a part of the said affidavit, which is at page 445 to page 457. Wherein various details have been mentioned as to how the hydrogeological survey and the geophysical investigation would be carried out. In addition to that, it is also mentions the terms for payment at clause number 5. The report further states that the same had been prepared for the respondent number 10. Upon receipt of this upon receipt of the said report submitted by Parson Overseas Private Limited, the head of the Department of Civil Engineering, IITG, has reverted back by issuance of a communication on 18/7/2024. Making various observations on the said proposal. It is also seen at clause number 6 of the said communication dated 18/7/2024 that the IITG have also sought for the notable case histories where Parson Overseas Private Limited was involved in groundwater flow and spring investigation of hilly regions, to the said communication dated 18/7/2024 issued by the IITG, the cluster project manager, Northeastern region of the respondent number 10 had submitted a reply dated 26/7/2024, which was forwarded by the executive engineer PWD to the head of the Department of Civil Engineering IITG on 26/7/2024. The said reply, so submitted by the LNT, also encloses various documents which have been marked as Annexure A and Annexure B. In pursuance thereto, the head of the Department of Civil Engineering, IITG, had written a communication to the Executive Engineer PWD on 3rd of August 2024. The contents of the said communication, being relevant, is reproduced herein under page 473. Mr. Isaike, the learned Advocate General, submitted that the PWD building on its own would not be carrying out the geotechnical investigation, including the hydrogeological and geophysical investigation, but it would be done through expert agencies
the agency, the consultancy agent, that's LNT. We'll have to do it through LNT.
expert agencies provided which would be provided by the respondent number
No,
10.
That is not out. We engage LNT for all the works. EPC. Under the module,
Ah.
EPC,
Who submits that the
in this
the
case,
same would be done by LNT,
LNT who
who would engage expert agencies.
No, my submission is very clear. We have selected a agency under that NIT. So that
LNT.
agency,
You have selected LNT.
and because two participants were there, one is LNT, another one is Nagarjuna. So LNT was successful.
So is
All
it
these works are entrusted to LNT. So LNT can do with any agencies.
okay? Now who
They are called the EPC contractor.
understood? So you will the geotechnical investigation, including hydrogeological and geophysical investigation, would be carried out by LNT through
All the works will have to be done by EPC contractor.
understood
Yes,
LNT through expert agencies.
two expert.
That is what I am writing.
No, straightway we cannot give it to anybody.
No, you are not.
We are channelizing. We have entrusted LNT, who is the EPC L1.
So and so submits that the PWD building does not have the expertise on its own. But in view of the work order being issued, in view of the contract entered into with the respondent number 10, the respondent number 10 shall do it through expert agencies. And in that regard, the respondent number 10 have roped in Paragon person, have roped in person
versus private.
Overseas Private Limited, which is an expert body to carry out such investigation. The learned Advocate General, further referring to the MOU dated 25/6/2024 drew the attention of this court to the scope of the work and submitted that it is only upon the vetting by the IIT Guwahati to the geotechnical investigation oblique the foundation selection, structural design and drawing, work plan and execution methodology, the construction portion of the EPC contract can be proceeded with. The learned Advocate General further drew the attention of this court to Annexure A of the Memorandum of Understanding, wherein, while referring to the designated work assigned to the PWD building, which is providing all available information regarding existing project site as per requirement of IITG and geotechnical investigation of area by engaging third-party agency as per advice of the IITG. All other responsibility is with the IITG, that is specifying of area where geotechnical investigation would be carried out, semicolon, technical advice oblique examination of geotechnical investigation report prepared by the PWD building of the area, including the observations related to the identified subsurface features as stated in the report, semicolon, vetting of geotechnical investigation oblique foundation selection report submitted by the PWD building for the new construction related project, as well as the vetting of structural design and drawing, work plan and execution methodology provided by the PWD building. The learned Advocate General therefore submitted that from a reading of, from a perusal of the materials, which is the Memorandum of Understanding entered into on 25/6/2024, and the documents which have been enclosed to the affidavit filed on 6/8/2024, it would be seen that the authorities concerned have been taking due steps so that there would be no damage to the sacred natural water springs due to the construction of the Ma Kamaikha temple access corridor. This court, upon perusal of the materials on record and the submissions made by the learned Advocate General, had put a question to Mr. R. Borpujari, the learned counsel representing the respondent number 10, as to whether The geotechnical investigation, including the hydrogeological and geophysical investigation, is a part of the EPC contract so awarded to the respondent number 10. This court further inquired with the counsel for the respondent number 10 as to whether the expert agency Person Overseas Private Limited is engaged separately or is a part of providing the expertise in view of the EPC contract and inclusive of the EPC contract so awarded to the respondent number 10. Mr. R. Bapujari submits that he would take instruction in that regard. When
1 week.
okay, list this matter again on 13th. 20. List the matter again on 28, 2024.
I have a request, Vinod. I am not in the country until the 20th. Could your lordship have it on 21st or 22nd? 21st or 22nd?
22nd? 22nd? 22nd of August 2024.
I may like to furnish that to an affidavit, the contract agreement. The contract agreement between.
Bring it. No, only thing, see, Mr. Advocate General, this court has nothing to say about what, that is why I have quoted what has been stated by the
It's a very
IITG. If this what he has done, then I don't think there is nothing to enter into. Once this IIT, if IIT is doing it in the right direction, I have nothing to do.
This person, they will be just collecting the data. This
No,
data
no,
collection.
no.
And
They are not.
everything will be done at the
No. They have to also know that the collection, how to collect the data.
That is one. That is one. But the area, there will be a joint inspection with IIT and.
Whatever may be,
It is
whatever
already
may
there.
be, but you see, I have no quarrel with that. If it is done by LNT, the LNT, you see, then the responsibility can be put to them. You don't make it to a small contractor. If a small contractor makes a mistake out there, who is taking only 5 lakhs or 5 crores
LNT
something.
will never dare to involve a person.
No, I'm not on
Yes,
that.
yes, yes.
Whether they dare or not, let them come up on an affidavit that we do not dare to keep small person.
Lord,
Let them have the best of it.
yes,
That is
and
the
they have
reason
done
why.
it with the Indian Army. This agency, they replied to IIT that as the LNT replied, they have done it with the Indian one is Hyderabad Hydrological Center, and the other one is with Indian Army.
For rainwater harvesting.
Yes, my friend will agree to that. He has
Rainwater and rainwater harvesting, Manoj, for rainwater harvesting.
No, whether they have the expertise for that. Because then you see the responsibility.
I understand.
I want to put the responsibility on LNT. Not on the area, because later on, they should be responsible. Because they are a bigger contract. You don't want it to give it to a 5 crore when the contract is for IIT. Because this is the most important sector. IITG, I have full confidence they would do it. There's no quarrel with that. But the responsibility is whose? That is what I want.
Highly obvious.
Grateful. Great.
That is still pending with the government. That is still pending.
Why?
Because the report from the District Commissioner Sudipur has been sought for.
You are also a petitioner?
Yes, Your Lordship.
Come this side. Yes.
A report has been sought for from the District Commissioner Dorong, but I'm being telephonically informed that this land where the dispute arises between the two parties belong to Chairman municipal board, to the municipal board. Now, how the municipal board land can be given allotment to this person? So to understand the whole things, my lord, a report has been called for from the deputy commission, district commission. The matter is pending at that stage. The report is awaited from district commissioner Durham.
Does it require for that? How many years? 18 years for that. Does it require 18 years for that? 1 month?
Right.
Heard, miss?
Lordship, may I submit, Lordship? Earlier occasion, the respondent number 4 filed WPC number 4142.
Not necessary. I know what it is.
Order here, Lordship. This is still.
I can't touch that because that order has already been passed. Only thing I can do is dispose of, directing them to dispose of that representation. That is the only order I can pass because that order has already been passed, which has attained finality. We are referring to the order passed by Justice Saikia, A. Saikia, then.
In 2002.
Well, I can't touch that order. What I can do is only asking them to dispose of. The moment it is disposed of, the interim order gets vacated. So I'll ask them to dispose it of within 1 month. Matter ends there. And if they don't do, file contempt against whom? Commissioner and Secretary, Department of Revenue. Okay, both of you. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner in WPC number 1248/2024. That is him, the gentleman. And Miss So-and-so, the learned counsel appearing on behalf of the writ petitioner in WPC number 3652/2024. I've also heard Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the Revenue Department of the Government of Assam, and Ms. S. Sharma appearing on behalf of the District Commissioner, Ponipur, Tezpur. Both the writ petitions relate to in both the writ petitions, the petitioners are aggrieved by their action on the part of the Principal Secretary to the Government of Assam Revenue and Disaster Management Department in sitting over a representation so submitted by the writ petitioner in WPC number 1248/2014 for the last 18 years. It is seen from the materials on record that the petitioner in WPC number 1248/2024 filed a writ petition before this court, which was registered and numbered as WPC number 4142/2002. In the same writ petition, the petitioner therein sought for settlement of land admeasuring an area of 1 biga 19 letters covered by periodic Tiras Patta number 220 under Bagmara Moja, village West Jhingia in the district of Honitpur. In addition to that, the petitioner therein also sought for that the land be made free from encroachment of the respondent number 4 therein, who is the petitioner in WPC number 3652/2024. In addition to that, in the interim, the petitioner therein also sought for a direction that the respondent number 4 therein should be restrained from further construction of house in the land which the petitioner in the land in question. On 23/7/2022, 2002, in WPC number 4142/2002, this court, the coordinate bench of this court, issued rule and in the meantime directed that the respondent number 4 therein, who is the writ petitioner in WPC number 3652/2024, should refrain from making further construction in the land till the disposal of the writ petition. The respondent number 4 therein filed an application seeking vacation of the said order. Dated 23/7/2002. However, it is not known what happened to the said application seeking vacation of the interim order. Be that as it may, on 11/9/2006, this court, by an order, closed the writ petition being WPC number 4142/02, directing the petitioner therein to submit a detailed representation before the Secretary to the Government of Assam Revenue Department, highlighting all the respective grievances narrated in the writ petition, as well as in the misapplication number 1735/02 within a period of 30 days from the date of the said order. And on receipt of the said representation, the concerned competent authority was directed to dispose of the same after hearing all interested parties, including both the petitioners in the instant proceedings. Both the petitioners of the two writ petitions herein, in accordance with law and within a period of 2 months from the date of receipt of the representation. It was further directed that till the disposal of the representation, the interim order whereby the petitioner in WPC number 3652/2024 was directed not to carry out any construction would continue. The records further reveals that the representation was duly submitted on
12/4/2007.
12/4/2007. Page
28.
of your petition.
48.
2007. To the Secretary to the Government of Assam Revenue Department. Thereupon, on various, there was certain hearings being conducted by the said official. But a period of almost 17 years have passed by. But till date, no order has been passed disposing of the said representation. The petitioner in WPC number 1248/2024 had in the meantime submitted various other reminders for disposal of the said representation, which has, however, fell into the deaf ears of the respondent number 1. In a similar manner, the petitioner in WPC number 3652/2024 have also submitted representation taking into account the difficulty faced by the said petitioner in view of the interim order still continuing for the last 17 years. Compelled by the inaction on the part of the respondent number 1 and the apparent and the respondent number 1 and the deliberate inaction to take note of the timeline so stipulated in the order dated 11/9/2006. Both the petitioners in their respective petitions have approached this court for a direction to the respondent number 1 to dispose of the representation dated 12/4/2007. It is seen that in WPC number 1248/2024, notice was issued on 15/3/2024. And in WPC number 3652/2024, notice was issued on 26/7/2024. In spite of the notice issued in WPC number 1248/2024, the respondent number 1, that is the Secretary to the Government of Assam Revenue Department, still have not taken any steps for disposal of the representation. On 26/7/2024, this court directed the counsel appearing on behalf of the Revenue Department to apprise this court as to why it has taken almost more than 17 years for disposal of a representation. That too, when there was a specific order to dispose of the said representation within a time frame of 2 months. 2 months from the date of submission of the representation. Mr. A. Bhattacharjee appearing on behalf of the Revenue Department submits that some report have been sought from the Deputy Commissioner,
District Commissioner Sunitpur. District
Deputy Commissioner Hunitpur, District Commissioner Hunitpur, as to how the land which belongs to the Tezpur
Municipal Board.
Tezpur Municipal Board could have been allotted to either of the parties. This court, however, is shocked and surprised that this simple report, which can be sought for, had taken almost 17 years for disposal of a representation. Under such circumstances, this court directs the Principal Secretary to the Government of Assam Revenue and Disaster Management Department to dispose of the representation on dated 12/4/2007 within a period of 1 month from the date of the instant order. In addition to that, this court directs the Principal Secretary to the Government of Assam to file an affidavit of compliance before this court upon disposal of the said representation. Compliance to the instant order. About the stating as regards the disposal of the said representation. The registry shall provide a copy of the instant order to Mr. A. Bhattacharjee, the Learned Counsel for the Revenue Department, for forwarding the same to the Principal Secretary to the Government of Assam Revenue Department for effectful compliance.
The Principal Secretary is not a party.
What?
Principal Secretary is not a party in Konmai Das. Will it?
In one case he is.
Yes. In that case, Santosh he is there.
Wherever it is. Wherever. It is the Principal Secretary who has to do it.
Yes.
And file an affidavit of compliance on the next day.
Our representation is dated 13/4/20.
Not necessary. This order is enough for them. Your representation is for disposal. Then I've given you a much better order and asking them to file an affidavit of compliance. And if they don't, then I will take sumo motu. Don't worry. No contempt also required.
Much obliged.
With the above observations and directions, both the petitions stands disposed. 17 years. I upon 18 likhisu, 17 over the upon. Yes, your matter.
Was supposed to build the records.
In principle. टिकट को बोले फॉर्मेट वाला तो बना कम्युनिकेट कर नहीं होगा
Yes, what is that building? Which case you are there? There are two writ petitions. Why? Who is the other one? Abdul Matin?
Yes.
Yours is Abdul Matin. Or you are both not together but fighting analogously.
For now.
Okay. Yes. এইখন উলাই দিয়কচোন। Your land is how big?
My lord, that applicants, my lord, the land that has been indicated, my lord, in the DLC, my lord, minutes, page 76, per applicant, my lord, 1 bigha, then 16 katha, 2 bigha, like that. There are.
I am not, how many applicants are here?
My lords.
There are
In
eight, my lord,
non-permanent,
eight
8.
applicants.
All have paid court fees. Court fees? Court fees দিছে নে নাই? নহলে আমি decide নকৰো। One thing I have done good at the time of taking up these matters,
Perhaps, my lord, that will not be entertained in the filing section also. Perhaps we have.
4 is 50. This is 200, huh?
Perhaps that will not be entertained in the filing section also without the court fee.
Yeah,
That
this is
objection
much
comes.
better. At
Yes.
last I did something good. Yes, their lands, where?
My lord, I have stated in, my lord, para 3. First case, my lord.
2 bigha 11 kathas and 19 katha for 6 lectures. 19 katha 6 lectures is what? What is it? It is in where? Barakbeli. Chataks. Katha? 2 bigha 11 katha. 2 bigha 11 kathas. 7 chatak. Okay. Now, when did you file applications?
My lord, I have stated in para 5.
All are having brick industry. Huh? No, let us not get confused. Mr. Talukdar, your case is all?
I have stated, my lord.
All the petitioner enter into a mutual agreement and authorize the petitioner number 2 to install a chimney brick industry in the name of Brick Iman by duly following all government procedure and as such here. When did this thing happen?
No mention.
Huh?
No mention.
When?
Mention. No indication, no mention. No mention, no indication. When did they enter this agreement?
When?
It's not mentioned, my lord.
Which one makes Mr. D. Gogoi laugh, smile? When?
That is not mentioned.
If we go as per section 4, either first, if it is less than 10 years, then in that regard, you need to get the state government's approval. If it is more than 10 years, then the DC can do it. Without that essential feature being mentioned in your petition, how is it possible?
My lord, the lordship will kindly see that regard, section 4 makes it clear regarding the 10, my lord, years. But while, my lord, considering the application, my lord.
No, you are to only consider on these aspects, nothing more than that. You see, section 4, such land which is recorded as agricultural land but have always, but also has been unfit for agricultural purpose or where there has been no agriculture for at least 10 years preceding the date of application of the permission shall only be reclassified, transferred to intended non-aggregate prior to approval of the Deputy Commissioner. That is, which is 10 years. No agricultural land under cultivation during the 10 years preceding the date of application for permission as required under subsection 1 shall be reclassified or by the Deputy Commissioner without the prior approval of the state government in the Revenue Department. This section shall not be applied where the agriculture not exceeding 1 biga is used for reclassified for construction of one's own dwelling house. You don't come under that. Now let us see your application. So what is required to be done? The Deputy Commissioner shall accord an in-principle approval or deny approval accordingly altogether for allowing reclassification come to as the case may be within 30 days of the receipt of the recommendation of the circle officer, and while doing so shall take the opinion of the district level committee headed by himself with the officials drawn from the relevant demand as the case may be, provided that in case the total area intended to be reclaimed is above 50 bigas, the Deputy Commissioner shall accord his in-principle approval only with the prior permission of the Imam. Before issuing an in-principle approval under subsection 4 of this section, the Deputy Commissioner shall take prior concurrence of the local authority. Iman. Once the in-principle for reclassification come transfer is accorded, it shall be mandatory on the part of the owner to remit the prescribed reclassification premium. Yeah, we need not go to that. We are only here to at 4 and 5. So what is required is the basis. What is the basis on which it is to? No agriculture shall be put to non-agricultural use without payment of the So you come under what? Under what? Let us see your annexures application. Where is your application? Your application for NOC for reclassification has been submitted. You submitted on 5/12. Name, address, so and so. These are applications. There is no date. Then
One letter which could not be annexed, communication of the, my lord, revenue circle officer, deputy commissioner, my lord. This, my lord, indicates that in 22 itself, application was submitted, but as the portal was not functional, my lord, that could
it's
not be
okay,
annexed.
but there is no basis on which it is being done. I have no objection in reclassifying the plot to Iman and remain. There is not even a word used. Why? These recommendations made by the Assistant Director of Agriculture is also wrong. How can you, how is he giving it without there being any finding? Something is wrong with these people. I'm directed for reclassification in the conference hall. Attendance of so and so. Okay?
My lord, they didn't wait for the approval also.
Has proposed the
They established the industry
reclassification
itself.
land of so
Photographs are
and
annexed.
so proposing. This is not the basis on which they do it. Entire thing is wrong.
the original record, your lordship will peruse it, my lord.
Where about the original record? Your records? Where is 10 years? Where is less than 10 years? When did you enter into an agreement with petitioner number 2? Chimney, from when? You applied on 5/12/2023.
No, my lord,
Okay, you may have earlier applied for whatever may be, but where is it anywhere shown that for the last 10 years, anything else? You can't convert it one fine morning, okay, I want to, you see, the idea, the reason assigned by the agricultural officer, see, shows that these persons want this for getting some job or something. Means for conversion of their, for learning a livelihood or something to that. Nothing more than that. If we allow this type of petitions, then it, and you see, as an industry of such time will create economy of its own, along with the number, so I have no objection. Right? If these type of things are being given, then God save the agriculture department. What do you say?
My lords, even that act, my lord, section 10. Section 10 of that act. Assuming we all are wrong.
No objection for reclassification is accorded by the commissioner under so and so. It shall be mandatory for the owner to establish the approved so and so demand. If the owner of the fails to establish an approved non-agriculture within the period as mentioned in subsection 1, how is it relevant?
Well, 3D has come.
Huh?
3D has come now. 3D has come, my lord. Now, is it this industry is going to be established any day?
That's a different thing.
That's a different issue. Therefore, my lord,
That is not the issue. But the first is, how is it possible?
how is it possible?
You
And
don't do it in this manner.
therefore, my lord, I was, my lord, please, lordship will come to the section which says in principle approval, my lord. In principle approval does not confer any right, my lord, unless until it is converted to an order and communicated to the party, only then right is crystallized in his favor, my lord. I just got a judgment.
Who has given in principle approval?
My lord, it's just assuming, my lord, the DC, they say that DC had given approval, which was cancelled on the behest of us.
Where?
My lord, see that
Verbally telling them. Where is the in principle approval?
DLC, my lord.
Page?
DLC headed by DC.
Page, in principle approval, where?
I need
The
my lord.
order itself.
Impugn order,
Page
my lord.
80.
Page 80.
Approved in the DLC meeting.
19 so and so for reply. In pursuance to the letter received from the remand, the 19 numbers are for reclassification of land approved by the so and so. It's approved by whom?
That is their case, my lords.
Approved by the DLC. DLC has no business.
Yes.
DLC we may make a subway, yeah, but that has to be taken by the yeah. Therefore, it has come before the district commissioner. But I don't understand how can the DLC also, without considering anything as to whether it is fit for agriculture or not, that is the most pertinent aspect which needs to be taken.
My submission. Here, your lordship will kindly see the procedure is followed. That is not under challenge. Now, the deputy commissioner has also not cancelled on the ground that the procedure which is prescribed, has not been followed. Now, after consideration of all the material collected from the circle officer and other authorities, the deputy commissioner accepted those applications because your lordship will see what section 5 say. Section 5, subsection 4. The deputy commissioner shall accord in principle approval or deny approval altogether. Those applications were considered, was not denied, not refused. And thereafter, the recommendations of the district level committee in terms of section 5.4 was accepted. And deputy commissioner, they say that approval has been granted. So therefore, essentially, the cancellation.
Essentially, you want an order that this court should not interfere with the deceased order, but for good other reasons. Because on the face of it, you see, what is the basis for reclass? One has to understand that if our agricultural land is not fit for culture, therefore, within 10 years, the DC can do it. More than less than 10 years, the DC can do it only with the approval of the state government. But the basic thing is whether it is fit for agriculture. Which authority did it consider? Even the agricultural officer says these people will get employment, therefore I have no objection. My goodness.
Materials might not come on records. So we kindly see the original records, whether anything, there's semblance of that.
Forget about these. These orders are on the face of it perverse. The order passed by Deputy Commissioner, I am not saying that it is good. That is also bad. No quarrel with that. That is also bad. But your entire thing goes.
I'll try to bring on record if I find anything.
What? There is nothing. We have already spent so much of time. Matter goes for a 6th day.
On Friday,
Why? Friday is subject to cost. 15,000? 50. To the? How did I give it to the, what? Some NGOs.
If there is something on record.
There is nothing on record.
That may be produced by.
No, forget about the records. These records, the orders do not speak of anything that these are not fit for agriculture. Where is any letter out here which says that this is not fit for agriculture? That is the basis on which one can have it. Well, otherwise, no, Mr. Talukdar, one has to see a bigger picture. The picture is, if no,
in the first hour and.
gazetted notification, approved, so and so, all the required documents have been applied. Entering the area under local units in decimals of the so and so. Records are here. Draft notification, Kaldiram Bazaar section. Minutes of the meeting on 23, one meeting was headed. Previously approved assignment mostly follow the. Circle officer also says, which subject I have the honor to state that reclassified and enclosed in the annexure herewith has been forwarded to your end online mode. It may be noted that there is a zonal valuation against so and so, which is not yet been approved for the government. As such, instruction is sought in the light of the above whether to be considered. In the instant case, as per the concurrence of the and further process up to the level of stage C has been completed in meantime, so and so has requested the undersigned not to reclassify the existing class of land. There it may be further. Your order, your good case is this document. You can grab it. This is your, what do you call, the main document for your case. You can document. But only missing is, where is that? Not fit for any. It is the next page. This forms the basis of the impugn order. Absolutely. Therefore, impugn order is bad. There is no quarrel. But the question is, impugn order being bad, but the going to the impugn order is also bad.
But I request your lordship, at least the records, original records will be produced. Original records will be produced, lordship will keep it for that. Lordship will at least produce the original record. Here these documents are sent, my lord. My learned senior has started with saying that the photocopies are sent. My lord, what is the note sheet? What is the file? And that your lordship can produce. If your lordship does not find anything, lordship will, my lord, reject my application. For my satisfaction. Because I may not have access to all the documents, my lord. So I could not annex here. Lordship will at least produce the original record. If a lordship does not find anything, well and good, lordship will find that must and say on. If I request your lordship that much. And in the meantime, if I find some documents, I'll also put on record. Lordship will keep it part of man. That
Oh, pardon me. These are matters not part.
not take up next Monday or Tuesday. In the meantime, they will find the original record. At least that much. And in the 3A notification, they have identified this land as pilot, industrial land. 3A notification, they have identified this land as industrial land. 3A notification is annexed by them. It's shown as industrial.
How?
No, my lord, that I will dispute, my
And
lord,
subsequent-
because my lord, the notification I have annexed doesn't that doesn't classify anything as pata number is not indicated there.
I show you.
So I'll just,
No, it is there. I'll show you. Where is the affidavit?
Well, I'll show you a lot. Lordship come to
yeah,
page,
my 91 of us.
Lordship will come to page 106.
No, 106 3D.
ঠিক আছে?
What the division of a title of it?
Please see.
91 of Lavo, village name is Bhuja.
Now, this is under 3C.
They are referring to 3A.
These lands have been shown as industry,
Yes. Industrial land.
village, part.
Page 107, Melo, I can show the dark numbers. 284, 286, Melo, 293, 294, 295, 296, 424, which are dark numbers in respect of the present expenditure.
Then you did not oppose because of that.
Thereafter, Melo, they have issued the 3D without giving an opportunity under 3C, they have again reversed it, man, showing as agricultural land. That has been done by them. In the 3D, my lord, this has been reversed as
Are you
agricultural.
challenging that?
No. Subsequent, they have annexed here, my lord. In subsequent to the.
But don't you think that you need to challenge them? But I was going to go. But we have not challenged that. Please see.
107, my affidavit doesn't contain last first page like that. Abdul Matin না মাটির না হেৰি মোৰ নামটো জানো মানে অনন্তটো কওক সেইটো কওক
অনন্তটো 1 নম্বৰ আছে
অনন্তটো এইটো মই ঠিক মাৰিছো
Where is the 3D?
3D goes to my lord
3D, my lord, page, start from page. Next has the page
121.
121. It's shown as agricultural land.
Mr. Talukdar, you produced the original record. Next Thursday. Thursday it can be done. It's on next Thursday to Thursday.
Can it be after 15th?
Have it on 22nd. It seemed that this code by the specific order asks Mr. P.J. Taluk, the legal counsel appearing on behalf of the district commissioner, Karimganj, to produce the records. However, certain photocopied documents have been placed to stop. It seems that in spite of specific directions, the district commissioner, for reasons best known, have not placed the records. Under such circumstances, this court fixed the matter again on 28/2028. It is made clear that if the district commissioner does not produce the records on the next date, this court would have no other option but to call for the personal appearance of the officer concerned. Take whatever need. Nowadays, everything is available in the net. Why? It is very much available everywhere. Or you take a photocopy, print a certificate copy, give it to him.
I'll give it.
All right. That you spoil the time of the court. Hey, you take these two. But this is, if it goes against you, ready, both of you, 15,000, 15,000. SK Talukdar and Mr. GME Choudhury, not to the clients. But prior to that, take it whatever you want from the clients. Yes.
I started the construction with the due permission of the PMD and PMC.
Huh?
When I started the construction of B+2 building over my land with the due permission of the that is PMD, PMC. The
Then?
army personnel came and said that they.
Watch the impugn letter. Which is that? 11/1/2024. Where is that?
Page 22.
Page
22 of the petition.
22. Oh, these 50 meters. That day I disposed of a matter.
Now this is under consideration of the authority lordship because GMDA had submitted.
You along with the other workers at Patta number so and so were constructing a building which is located within 50 meters from the boundary of the bench. You are personally intimated by the undersigned on Iman to stop construction work and resume the construction only after obtaining the no objection from the AR. Again on 10/1/2024, it was observed by our unit guard that the construction was assembled in your plot. You are hereby intimated that no construction is permitted up to the distance of 50 as it is concerned. Since the yeah. Now, tell me, madam, show me that Defense Government of India Defense Circular. Where is it?
It's 2011 and 2015.
No. This order refers to 2023.
23 lordship. That is page 58.
What does it say? Kindly come to clause 3B. What construction you are making? Ground plus? Ground plus 2. Read 3B. What did it say? You have the 2011 notification?
Yes, Lordship.
Read B. Yes.
Lordship. Where the local municipal laws do not so require, yet the station commander feels that any construction coming up within 100 meter, for multi-story building, it is 500 meter radius of defense establishment can be a security hazard. It should refer the matter immediately to its next higher authority in the chain of its command. In case the next higher authority is also so convinced, then the station commander may convey its objection or views to the local municipality or state government agencies. In case the municipal authority or state government do not take cognizance of the said objection, then the matter may be taken up with higher authorities, if need be, through headquarter or Ministry of Defense.
Did you do anything?
Now, Lordship, it
Did
is
you do anything? Anything of that?
this later, Lordship, here he said that you have to obtain no objection from.
Right. Did you do anything? This doesn't say any no objection. Where the municipal law does not say so, what to do?
The station commander, if feels that there is a hazard, then
Security hazard. Where is your opinion?
station
That is a
commander.
security hazard? Okay. Now come to the 2023 circular.
That is kept in abeyance, Lordship, that
2022 has been kept in abeyance, not the 2023. Got it?
yes, Lordship.
Read 4B, 4D,
3B.
4D.
If ongoing construction in restricted zone is not perceived as a security threat, in case views of station commander are not required as per the bylaws, and construction is not seen as a security threat by a station commander, then a station commander is neither required to raise an objection nor issue any NOC, and the individual should be allowed to construct on his property without any interference.
And so unless you come up with your satisfaction that it is a security hazard, you have no business to disturb his possession. Where is your finding? Where is your opinion? That subjective opinion is required. Now in that circular, kindly read 3B, which is parameter to B what you just read.
Well, local municipal bylaws do not require consultation with station commander. Where the local municipal laws do not so require, yet the station commander feels that construction coming up within 100-meter radius of defense establishment can be a security hazard. He should refer the matter immediately to his next higher authority in the chain of its command. In case the next higher authority is also so convinced, then the station commander may convey his objection or views to the local municipality or state government agencies. In cases the municipal authorities or state government do not take cognizance of the said objection, then the matter may be taken up with higher authority, if need be, through headquarter of Army or Ministry of Defense.
Oh.
Now, Lordship, there is a field verification by the authorities, and they have submitted their report to the higher authorities. That is the present position, Lordship.
So what is your business for asking them to give all these things? Unless you come, you cannot direct them. Unless you come, what power you have? You don't have any power. Because you are the army wearing a uniform, you can do anything. Something like that.
At that time, there was no opinion, but subsequently during pendency, after receiving this representative.
Do you have an opinion or not? I'm asking you that specific question. Have you formed an opinion that it is a security hazard?
at the time of issuance of this not there.
Happens. That is it that.
Earlier, your lordship already. Case.
But that is not yet uploaded. Only difference is that in that case, what my instruction is that is much narrower. This is much nearer the defense as the
You have to have that opinion. Without that opinion, you cannot. In fact, this is an application by which it is a complete case of non-application of my. I do one thing, I interfere with this only on that aspect without going into much. Because if I interfere much, because there in that case it was 100 meters, it is more than that. You may have an opinion. If you have an opinion, then you can very well take action in terms.
as per.
But without forming an opinion that that too by a station area, and the station commander can only have that opinion. Once he has to refer it to the area. Now tell me, let us see that particular clause again, 4B. Referring to the 2022. 2022 is not in, it has been given. Where is the other one, circular, the latest one? 2023. Where?
21st March 23.
21st?
March 23.
Where is that?
Page 65.
65. In fact, your circular, another problem is that, I tell you, this is a permission which he has got in the year 2023. The building bylaws has come in 2022. There is a provision out there where they require some consultation. But then also, you cannot do so in view of force D. Problem arises there unless you form your opinion. Let Mr. Upadhyay have a better day of construction. Heard Mr. P. Upadhyay, the learned counsel, appearing on behalf of the petitioner. Ms. B. Sharma appears on behalf of the respondent numbers
1, 2, 3, 4, and 5.
1, 2, 3, 4, and 5. None appears on behalf of the GMC or the GMDA on call. The petitioner herein is aggrieved by the issuance of the communication dated 11/1/2024, issued by the respondent number 5, thereby directing the petitioner not to proceed with the construction without obtaining the no objection certificate from the local military authority through the Guwahati Metropolitan Development Authority. The petitioner herein was also intimated that in absence of a no objection certificate from the local military authority, the office of the respondent number 5 shall initiate an FIR as per the government procedure. It is seen from a perusal of the impugned order that the same has been done on the basis of the guidelines for issuance of no objection certificate for building construction dated 21/3/2023. This court also further takes note of that the petitioner hearing have been duly accorded both the building no objection certificate for construction dated 9/1/2023 construction, as well as the planning permit, both dated 9/1/2023 by the GMC as well as the GMDA respectively. Taking into account that it is on the basis of the guidelines dated 21/3/2023 that the respondent number 5 had issued the impugned communication, this court finds it relevant to take note of the said guidelines. A perusal of the guidelines, more particularly at clause 3B, shows that where the municipal laws do not require yet the station commander feels that any construction coming up within 100 meters bracket for multi-storied building of more than 4 story, the distance shall be 500 meters bracket close, radius of a defense estate, radius of defense estate,
Defense establishment.
establishment, and can be a security hazard. The station commander is required to immediately move the next higher authority in the chain of command. In the case that next higher authority is also convinced about the existence of a security hazard, then the station commander may convey his objection or views to the local municipality or the state government agency. In case the municipal authority or the state government do not take cognizance of the said objection, then the matter be taken up with the higher authorities, if need be, through the IHQ and MOD bracket Army oblique MOD MOD. Full stop. It is also seen in clause 4D that in case the view of the station commander are not required as per the bylaws and construction is not seen as a security threat by the station commander, then a station commander is neither required to raise any objection nor issue any NOC, and the individual should be allowed to construct on his property without any interference. This court, upon perusal of the above guidelines, finds it that there has to be a subjective satisfaction arrived at by the station commander as well as its higher authority, immediate higher authority, that there is a security hazard in respect to the construction coming within the ambit of 100 meters of a defense establishment, or 500 meters if it is a multi-storied building of a defense establishment. This court have duly perused the impugned communication dated 11/1/2024, wherein there is not a single whisper that there is any security threat. Merely on the basis that it is a restricted zone, the respondent number 5 have issued the said communication, which is not only contrary to the guidelines dated 21/3/2023, but also clearly shows the non-application of mine. Accordingly, the impugned communication dated 11/1/2023 is set aside and quashed. The above the writ petitions can disposed.
Lordship, it should be 23/2/23, 21/3/23. Possibly
It is given at 21/3. Kindly come here. page. Yeah. Where did I see that? Yes, this one. Finally come page 65. Right? I'm right? Hey, to silo, huh? Command Quebec usually hey to judgment of a silo. Human down 5? At 4:45, what is the matter about?
Revolves around the disqualification of 16 number of employees of the RSL Assam Textile Corporation. What happened is that during this pendency, the AIDC minor has taken over the Assam Textile Corporation. So we have prepared an IA for impleadment matter. So let this matter come up with the IA matter.
IA has come.
It's not come today, but we have tried.
It has been submitted by the learned counsel appearing on behalf of Assam Industrial Development Corporation that an interlocutory application has been filed to stop in the instant writ petition, taking into account that the Assam Textile,
Corporation.
Assam State
Assam State.
Textile Corporation Limited have been taken over by the Assam Industrial Development Corporation. This is the matter again on number I. The said interlocutory application number is number.
Number I have. It is 88812 of 2000.
Filing was filed on
5/8/24. Yesterday.
5/8/2024. Taking into account the above, list this matter on 12th of August 2024 along with the said interlocutory. For this.
Please, Your Lordship, item number 9, my senior instructed that he is no more engaged in this matter.
Where?
Item number 9, WPC 41 of 2014. His name has been there.
Earlier you come up again, you have lost the bus. Again make the same submission. We have already. Atlanta Modular Limited. Oh, itu. There is an administrative order. So it won't go up. None appears on in behalf of the petitioner or the respondent on call. To list the matter again on 22nd of August 2024. At the top of the list. Yes, what is this? All central government council this side and you are another central government government this way. I thought all are here means something, some big matter must be there.
Any other neighbors?
What is this? What are these matters for?
Eviction from railway land.
Huh?
Eviction, railway land.
Eviction? How?
Lordship, first case is filed by railway. That is for cooperation for eviction process, asking for some cooperation from state government for maintaining law and order situation. During that, Lordship had once heard it for some time, Lordship.
Huh?
Once it was came before your Lordship, and Lordship also directed railway to file an additional affidavit and eviction notices were issued. I have filed that, Lordship.
No, what are you challenging here?
Evict, Lordship, the railway needs some cooperation from state government.
Directing the district administration Sibsagar and Jorhat to cooperate with the petitioners and provide all necessary assistance in evicting the unauthorized. Then that is all it. Then this is by who are the others?
During that,
Against this, the railway authority issued notice for eviction, although the land is not belong to railway. That is our case.
Who has issued notice? Railway means? Where is the notice? Oh, you are also railway. That is why we see this. That is why I was thinking, how is it possible that there are two railway councils this way and one railway council this way? Yes,
One is for assistance, Lucy.
44 or not.
page 44. Who have issued?
Yesterday.
These are notices issued under section 4. Go there, file your reply. Matter ends there. What is
They
this?
preferred appeal, man.
Where?
They preferred appeal.
They've decided.
Appeal has been decided.
Appeal decided. What is there? What else is required to be decided?
They have not preferred appeal.
They have not prepared appeal?
No, no, Lord.
Then
Page 55 or not.
page 55 of what page 55? Where?
Page 55, order, your lordship will find order, passed by the appellate authority,
What are you challenging here?
So since the land does not belong to railways, so railway authority has no power to ignore it.
No. That is been decided here. Who has decided it? What are you challenging? So and so written the nature of statutory should not be set aside. Annexure by respond number by so-called notice. Demand. You are not challenging that appellate order?
No, Lordship, no.
Appellate order is in our favor, Page 66, your lordship will find.
He is not the petitioner, Lordship. That is other sets of Lordship persons.
You are you any of the party to the where? Show me one.
Page 55, owners penalty objection we have filed.
No. Show me from this order at page 61. Where is this person and any of these persons are a part of the petitioners? Let us see. These are cases of cost.
3 mile.
Huh?
Topondas is one of the.
Page 60,
63 mile.
63, Topondas. Where? Where is Topondas?
Is appeal number 9 of 2006.
No, where is Topondas here?
The appellant, name of the appellant.
Where is Topondas here?
Little put.
Huh?
There are beds of repetition.
No, where is Topondas?
Well,
Come
other
up with all
connected
this.
matters.
Huh?
In other connected matters.
Where is Topondas? This one. They will have 4611. 4611. Yeah, Topondas is there.
But here, Lordship, in item number 12, Lordship, not a single person in the party.
Okay, so this goes. And then why you are not replying to them that this has been already decided? Why you are not replying to them that this has already been decided and you have come before this court?
The authorities are visiting the places, threatening the people.
Very good. They cannot, whatever I know, one thing, the railway authorities are not going to throw you out unless they pass that section 5 order. As of now, this was the matter which have been adjudicated in a misappeal, wherein it has been held that this is a government land, why you are not placing it before them? How can this court decide if it is a government land or not?
Kindly peruse for a moment, kindly peruse order dated 12/7/2018. Last part, the second paragraph. 12/7, initial order passed by.
2022. Yes, what is this?
Last part, the second
The
paragraph.
revenue is important in this case as the question has been regarding the ownership. According the revenue authority is directed to clarify. They will clarify, they will get it from here.
I've got the
Okay, what is there?
10 deals with the railway line.
Fantastic. You want this court to close everything today. You see how many, Mr. Saikya, kindly appreciate how much of opportunity is left. You file your objection. They will pass an order under section 5. After taking into account, you get a few days. Thereafter, you file an appeal. District judges are always busy. The district judge will take some time and then again you come. Now, if I today decide and say that this is a railway land, your everything is finished. What to do? See, series matter goes like this. And you wanted time at right?
Yes, logic. That interim order or their is related to only one specific key state. Other cases, logic, the state administration may cooperate for eviction. All the cases is support these.
No, you want the cooperation of the district administration. Obviously, district administration will help you. They are to help you as per the provisions of the Assam public premises, right? But why are both these matters taken together? And it shows a very poor image on the railway. The railway council is and the petitioner council standing together.
Because of all these matters.
Yes. He's withdrawing.
Administration is automatically
He's withdrawing. You are withdrawing or dismissing? Withdrawing with liberty to file a PPA, and I'm giving you 10 days. 10 days for filing your reply. First, now I will segregate this. It looks very poorly on the. You can't be 47861 cannot be allowed. Third, Ms. B. Sharma, the learned counsel appearing on behalf of the Northeast Frontier Railway, who is the petitioner in the writ petition. Mr.
State is the only party.
H. Sharma appears on behalf of the respondent numbers 1, 2, 3, and 4. The petitioners in the instant petition are aggrieved by the inaction on the part of the respondent authorities, more particularly the district administration of Sibsagar and Jorhat, to cooperate with the petitioners and provide necessary assistance in evicting the unauthorized occupants encroachers from the railway land.
In this case, Lordship, we have filed our affidavit. Our stand is that because of the interim orders passed in the other 4 cases, because of that, we are unable. That was our affidavit.
Ms. B. Sharma, the learned counsel appearing on behalf of the railway, on behalf of the Northeast Frontier Railway, submitted that the railway lands being public premises, the district administration is required to provide the necessary help, else the provisions of the public premises unauthorized occupants, what is the full name?
Occupancy Act 19.
Public premises, Eviction of Unauthorized Occupants Act 1971 would become redundant. He further submits that the district administration has the manpower and the resource so that the said provisions of the said Act of 1971 can be given due effect. Mr. H. Sharma, appearing on behalf of the respondent authorities, submits that the respondent authorities are not adverse to providing the necessary cooperation with the petitioner while exercising its jurisdiction under the Act of 1971. However, in the instant case, in view of certain interim orders being passed, the respondent authorities were not in a position to provide the resources and the manpower. This court by the, it is in the other matters, no?
Yes, Lord.
Other matters.
12 to 16.
At this stage, this court, next paragraph, at this stage, this court finds it very pertinent to observe that by an order dated, as it did to, this court have already disposed of the writ petitions, wherein interim orders were passed, giving liberty of 15 days, 10 days, 10 days. How much time is given for filing reply? 10 days, public premises?
10 days.
Giving 10 days time to the petitioner therein to file their objections in to the notices issued under Section 4 of the Act of 1971. This court also have taken note of the provisions of the Act of 1971, which duly empowers the petitioners, the estate officer of the petitioner, to take appropriate to initiate action for eviction of unauthorized occupants, as well as also pass necessary orders in regard thereto. After coming to an opinion that the land or after coming to an opinion that the property is a public premises within the meaning of the Act of 1971. This court also is of the opinion that as the district administration of Sibsagar and Jorhat has the manpower and the resources, and if the state authorities do not provide the necessary cooperation, the provisions of the Act of 1971 would become redundant. Under such circumstances, this court disposes of the instant writ petition, thereby directing the district administration of Sibsagar and Jorhat to cooperate with the Northeast Frontier Railway upon actions being taken in accordance with the provisions of the Act of 1970. With the above, the instant petition stands disposed. Heard Mr. P.J. Saikia, the learned counsel, appearing on behalf of the petitioners in the instant batch of writ petitions. Mr. K. Gogoi, as well as Mr. S.K. Medi, appears on behalf of the Northeast Frontier Railways. Mr. A. Bhattacharjee appears on behalf of the Revenue Department of the Government of Assam. And Mr. H. Sharma appears on behalf of the District Administration of Sibsagar and Jorhat. Are they both parties? Sibsagar and Jorhat?
Only Jorhat.
Huh?
Only Jorhat.
Jorhat
In 12, Jorhat.
appears on behalf of the District Administration, Jorhat. The instant batch of writ petitions. In the instant batch of writ petitions, the various petitioners herein have approached this court by assailing notices issued by the estate officer of the Northeast Frontier Railway under Section 4 of the Public
Public premises, within bracket, eviction of unauthorized occupants.
hereinafter should be shortly referred to as the Act of 1971. This court, the issue, the counsel appearing on behalf of the petitioner submits that the land in which the respondent number, the estate officer of the Northeast Frontier Railway have issued the notices are government lands but not railway lands. And as such, it being not a railway land, the estate officer of the Northeast Frontier Railway has no jurisdiction nor authority to issue the said notices. To the said submission, Mr. K. Gogoi as well as Mr. S. K. Mehdi, the learned counsel appearing on behalf of the Northeast Frontier Railway, submits that the lands in question are railway lands. And in that regard, submits that from the documents, it is and submits that the records are available to show that the said lands are railway lands and not government lands. Next. The question as to whether the lands in question, upon in respect of which notices have been issued to the petitioners in the instant batch of writ petitions, are government lands or railway lands, would require an examination by the concerned, would require an examination to be carried out. It would require an examination of facts. It is the opinion of this court that the petitioners herein, opinion of this court, that the estate officer, that the petitioner herein can very well bring the aspect as to whether the lands whereupon they are possessing are government lands or railway lands by filing necessary documents in support thereof. And on the basis thereof, it is further opined that it is on the basis thereof, the respondent, the estate officer of the Northeast Frontier Railway would be in a position to decide as to whether the lands in question are government lands or railway lands. Mr. P.J. Saikia, the learned counsel appearing on behalf of the petitioner, also submits that there is a judgment passed by the district judge in various misappeals, in various appeals filed under Section 12, Section 9 of the of the Act of 1971, wherein similar lands have been held to be government lands, government lands, and outside the jurisdiction.
That was not held. Issuance of notice under Section 4 is illegal, held to be illegal. Right then.
It is your submission to that effect that what was held?
The appeal, appeal.
Why?
Since the kindly page 70 of that.
Why?
It is taking into account the object and reasons of the I am objective considered as to be observed any person are in unauthorized and or he or she can be proceed with the provision of the Act 1971 and the rules made there. Accordingly, appeal is partly allowed on contest without any.
Appeals are decided against you?
Partly allowed.
How?
There is no reason except that.
Forget about it. Then don't refer to that judgment. In continue. Taking into account that these questions of facts as to whether the land where the petitioners are in possession are government lands or not, or railway land, this court disposes of the instant writ petition, thereby giving 10 days time. You have to take certified copy, no? 10 days time from today for submission of their reply to the estate officer against the show cause notices issued, along with the necessary documents. This court further observes and directs that in the circumstance such objections are being filed, and it further observes and directs that the estate officer of the Northeast Frontier Railway thereupon shall proceed with the disposal of the said so-called proceedings in accordance with the provisions of the Act of 1971. It is, however, made clear that till the disposal of the so-called proceedings by the estate officer of the Northeast Railway, they cannot take any action for eviction of the petitions.
The interim order passed.
Interim orders passed earlier stands vacant.
That's all.